mounted on the wall behind you there. There are 2 video cameras which are mounted on the wall behind us up here. And those cameras are recording these proceedings first for streaming on the city's, I guess on the website for the city's cable access network, in addition to recording it for the city's YouTube channel, and also storing it on that network as well for subsequent broadcasts. So cell phones, pagers, conversations, etc. also interrupt or interfere with that process as well. We will be voting at the end of the day, and you're certainly more than welcome to hang around and enjoy a civics lesson if you so choose. But if you've got other plans for this rather soggy Tuesday afternoon, that's quite understandable, and you can call into the zoning board office in the morning and find out how we ruled on your case. If you take out pen and paper, I'll read the number off to the zoning board office a couple of times. That number is 410-396-4301. Again, 410-396-4301. You will, however, need to wait until you receive the formal written notice of the outcome of your case, which should be forthcoming in about 3 to 4 weeks before you'll be able to obtain your permits. We certainly ask that you please not build in the city of Baltimore without first obtaining all of your proper permits. If you haven't already done so, if you're here in opposition to any case today, we ask that you please sign in on our sign-in sheet. It's being held up there by Mr. French. The sign-in sheet allows us generally to know which cases have opposition, but also allows us to know who needs to receive those aforementioned written notices, as I just was talking about. In addition, if your case gets postponed for any reason today, we need to know who you are and how to contact you to let you know when that case will be going forward, if it does not go forward today. If the procedure for when the cases are called, if you are the appellant, you'll come forward and you'll stand to our left or your right. The opposition, if any, will stand to our right or your left. Once everyone's up here, we'll get you sworn in, and then we'll begin with the appellant, who'll be given the opportunity to present their side of things. Basically, tell the board what it is they're proposing, present any documents or witnesses that they would like in support of their positions, and respond to any questions which the board might have. Finally, once the appellant is concluded, we'll then be turning to the opposition. We'll be given the opportunity to do the same thing, that is, present their side of things, their documents, their witnesses, etc., in support of their positions. Once the opposition is concluded, we'll then return back to the appellant to give them the opportunity to respond to any points brought up by their opposition, and then to offer a closing statement. We won't be going back and forth and necessarily delaying things any longer than is necessary. We will generally be calling the cases in the order in which they appear on our docket once we first dispense with some preliminary issues. First, we have a postponement. This case will not be heard today. 2017-268, 1300 through 1308 and 1310 through 1320 Russell Streets. That if you're here in that case will not be heard today. It's been postponed. And so long as you've signed in, we can let you know when that case will be going forward, but it will not be going forward today. Next are those cases which appear on our consent agenda. The consent agenda consists of those cases where the zoning board staff has reviewed the files in these cases, and the board has determined that we have the ability to approve these matters on a consent basis that is based upon the record as submitted. We're going to call all the consent cases together as a group, and the first person in line will line up here. Everyone else will line up down the dais behind them. Once everyone is up here, we'll get you all sworn in as a group, and we'll call each case in turn. And as we do, you'll be given the opportunity at that point to present any information that you would like to have added to the record at that time. First case on our consent agenda is 2017-229, 5139 Weathersville Road, William Detweiler. All right, next will be 2017-259, 612 South Bolden Street, Rick Vornador. And then after that will be 2017-269, 522 South Bethel Street, Eden Samaret. I'm up closer. There you go. If you can come a little bit closer, we got a few more people behind you there. Next, we'll have 2017-274, 901 through 925 North Milton Avenue, Carlton Gilbert. After that will be 2017-283, 504 South Decker Avenue, Steve Carroll. And then 2017-284, 1156 Hull Street, Carl Dyerberg. (2017-288) 1209 North Rose Street, Dana Young. That'll be it for now. All right, is that everyone? Okay. If all those giving testimony can please raise their right hands and be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, calling the first case on the consent agenda, 2017-229, 5139 Weathersville Road, William Detweiler. You're Mr. Detweiler?
Yes.
Okay, sir. We have this as an application to construct a rear and side deck at this location. Is that correct?
Mm-hmm. Yeah.
Okay. And Mr. French, anything for the planning department?
Martin French for the Baltimore City Planning Department. Planning Department has no comment on this application. Thank you.
Okay. And you know this is in the Dickeyville area. Is that correct?
Yes.
Okay. And Mr. French, will he have to go to CHAP for approval?
Yes,
Okay.
but that's
And
separate.
I've been through Dickeyville's Historic and CHAP.
Oh, you
So
already
that's-
have gone through CHAP?
Yeah, yeah. I think it was in the paperwork, but
Okay. Do we have anything in the paper, in the file?
We don't have anything in record, but we'll check with the planning department tomorrow.
Do you have anything?
I think I might.
All right, good.
He has an authorization to proceed from CHAP.
Okay, good. All right. Anything further?
No, no.
Okay.
That's,
If you need a copy of that, or is that your only copy, or?
it might be.
All right.
I think so. I don't have any.
Okay. I guess what you can do you have access to a scanner?
Mhm.
Okay. If you can give him back the letter,
Yeah.
and then just
Site.
when you get home, scan it to us, because the CHAP approval will be will be a condition on your permit.
Okay.
So long as we have that in the file, then you've satisfied it.
Mhm.
Okay. All right. Anything else?
No.
Okay. Zoning board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal. Good luck.
Okay. Thank you.
Next, 2017-259, 612 South Bolden Street, Rick Vornador.
Hi, I'm Jeff Bonador, same last name, Rick's partner.
Yes, good afternoon, sir. Good, thank you. We have this as an application to construct first and the second floor rear additions and rooftop deck of this location. Is that correct?
That's correct.
Okay.
All right, if you-
Mr. French, anything from the planning department?
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Vornador, was there anything further you would like to add to supplement the record?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you. Have a good afternoon.
Take care. Next, 2017-269, 522 South Bethel Street, Eden Samaret. Afternoon, good to see you again, sir. We have this an application to construct a two-story side and rear infill addition and rooftop deck at this location. Is that correct?
Yes, sir.
All right. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Okay, and is there anything you'd like to add to supplement the record in your case, sir?
No, we're just waiting for the neighborhood approval. We have a hearing on a month from today, on September 15,
Mhm.
and that's conditioned to get the CHAP to approve us to continue with this project, but can't do anything until you and them approve us, so.
Okay, same thing with the last case, if, when you get, I guess when you hear back from the neighborhood association and from CHAP, then just make sure that you supplement that, at that time so that we've got it all in the file, okay?
Thank you very much.
Anything else?
That's it.
Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to
Thank you.
approve the appeal. There you go. All right. Next, 2017-274, 901 through 925 North Milton Avenue, Carlton Gilbert.
Good afternoon.
Afternoon, sir. We have this as an application to install a new rooftop telecommunications facility with 8 panel antennas, 1 dish antenna with rooftop equipment at this location. Is that correct?
That's correct.
All right. Mr. French, anything for the planning department?
Yes, thank you. Planning Department has reviewed this application, noted that this property is in the East Monument National Register Historic District, and therefore requests that the board approve this subject to these conditions. The antennas and related equipment must be painted to match the building wherever they may be visible from the street and where they cannot be placed inside stealth enclosures to ensure they are visually unobtrusive. The panel antennas, microwave antenna, and related equipment will remain mounted as illustrated in the plans and elevations submitted to and approved by the Department of Planning, and the applicant will adequately mitigate any adverse effect as specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
Thank you. And Mr. Gilbert, are those conditions acceptable to you?
Yes, they are.
And is there anything further you'd like to offer to supplement the record in your case?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Good luck. Next, 2017-283, 504 South Decker Avenue, Steve Carroll.
Yes, sir.
Afternoon, sir. We have this as an application to construct first and second floor rear additions and rooftop deck at this location. Is that correct?
That's correct.
All right. Mr. French, is there anything from the planning department?
Planning Department has no comment on this application. Thank you.
All right. And Mr. Carroll, is there anything further you'd like to add to supplement the record in your case?
No, sir.
All right. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Thank you. Next, 2017-284, 1156 Hull Street, Carl Dyberg.
Hello, good afternoon.
Afternoon, sir. We have this as an application to construct a 2-story rear addition and rear deck at this location. Is that correct?
That's correct, sir.
All right. Mr. French, anything for the planning board?
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Dyberg, is there anything further you would like to offer to supplement the record in your case?
No, thank you.
Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal. Good luck.
Thank you very much, sir.
Take care. Next, 2017-288, 1209 North Rose Street, Dana Young.
Yes,
Afternoon, sir.
good afternoon.
We have this as an application to replace a 6-foot-high fence with an 8-foot-high fence in a rear yard. Is that correct?
That's correct.
All right. Mr. French, is there anything for the planning department?
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Young, is there anything further you'd like to add to supplement the record in your case?
No, sir.
Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal. Good luck.
Thank you.
Okay. All right, and 2017-272, 337 South Chester Street, Darren Zimmer.
Good afternoon. We're actually going to request a postponement for this.
Okay. All right, okay, Mr. Prettle, you're here with the applicants?
Correct.
Okay, and there was opposition that signed in this case?
Yes, I had a chance to speak to them just now. I was asked just a few days ago to be involved with this, and after reviewing the application and talking to the opposition, there's some inconsistencies with the application that I think need to be addressed, and we're going to look at some of the things that I've just heard today. And so I would request a postponement based on my limited involvement to this point, and hopefully be able to work something out and make it a little easier on the board as well.
Okay, okay. Just,
I'm asking if I can ask a question. That's all
If you want to come forward first, I just called the case, it means you come over to here.
Sorry.
Okay, and then we need your name.
Okay. My name is Ann Louise Novak. I'm a resident of the 300 block of Chester Street.
Okay, and ma'am, you signed in on this case?
Yes, I did.
Okay, so the applicant's requesting a postponement because they want to continue to speak.
Right.
You had something to add?
I have a question about a law that I had heard about in the city of Baltimore. And I'm not sure, or I can look it up, but I just thought I could ask it here today.
Okay, well, the board can't really answer legal questions.
Okay, so I'll just look it up.
So, yeah.
I'll look it up and then
Okay.
have a look it up. Thank you.
All
Just
right.
thought I could ask. Thank you.
I would request, if possible, that we could be on in 2 weeks, and I can talk to the board staff about that, but I'd just like to, put that on the record.
Okay,
I'd like to have it done as soon as possible.
sure, we'll get you in when we can and as folks' schedules allow.
Thank you.
All right, 2017-272, 337 South Chester Street is postponed. Folks, just make sure that you signed in, and then that way you'll get the notice when the case is set to be heard again. You'll get before then, yes. Okay. That's all right. Okay. All right. Next, we're going to handle the rest of our docket, which will include cases where opposition has signed in. And frequently we found that opposition is the result of either a lack of communication or a miscommunication among the parties, and frequently it can be useful to offer the parties an opportunity to have a dialogue amongst themselves to see if they can resolve whatever dispute they have. Obviously, if there are two parties involved in a dispute and they ask the board to resolve that dispute, one of those two parties is bound to go away disappointed with the result. So this is your opportunity to avoid that unhappy fate. I'm going to call off the cases where there is opposition which is signed in, and you can just stand where you are. I will ask if there's been any discussion between the parties and whether the parties would like to speak or continue to speak. You're certainly not obliged or required to take the opportunity to speak with one another, but we certainly do encourage and appreciate it. If you do desire to speak, we just say, just go out the double doors to your rear, have your discussion, see if you can get something worked out. If not, just come back in and we'll call you in turn then. 2017-271, 2745 Huntington Avenue. Who's in that case? Okay. And have you folks had an opportunity to speak?
Yes, sir. We've spoken with the folks from RNA about this, and we've communicated via email. So we're here to present our case.
Okay.
Live entertainment license.
Would you like to continue speaking, or?
I think we've gotten to the point where the conversation has pretty much come to a halt.
Okay. Everybody feel that way? Okay. Have a seat. We'll call you in turn. Yes. 2017-285, 3233, 3241 O'Donnell Street. Okay. And, oh, they stepped out.
We have talked, but it's not resolvable.
Okay, all right, have a seat. Okay, calling the first case, 2017-176, 1101 North Carrollton Avenue. Syed Mohammed. Forward. Yes. Okay, Mr. Mohammed, we have this as an application to use the premises use the first floor as a grocery store. Is that correct? All right. Sir, if you can raise your right hand and be sworn, please.
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. And do we have staff reports?
Thank you. Planning Department has reviewed this application, noted that this property is in the Sandtown-Winchester Urban Renewal Area. This urban renewal plan does not prohibit or further restrict this proposed use. and notes that the community has indicated a desire for a healthy food market at the location and encourages the community and the applicant to confer about making this an outcome of this application. The department recommends approval of the application, subject to any conditions which the board may establish in response to comments from the community. Thank you.
Okay. All right, and so are those conditions stated by the planning department acceptable to you?
Yes.
Yes? Okay. Why don't you tell us about what you're proposing here?
I don't speak English very well, and I try
You can use the microphone.
yeah, I don't speak enough English.
Pull it a little bit forward for you.
Okay,
All right. So you don't speak English?
very well, and I need to open daily grocery for that spot.
Okay. Do you have someone here with you, sir, who can help you communicate with us and help us communicate with you?
No, I can bring somebody out.
Okay. Are you comfortable going forward today? Can you understand?
Yeah, a little bit, yes, no problem.
Okay. Well, if you're comfortable moving forward,
Yes,
then we can sort of see where we
please.
can get to, okay? All right, what is inside what's inside the first floor right now?
First floor before is a store. That's is a studio in the back and a front store. And second floor we have apartment, 3 room, and kitchen and bathroom same thing, and downstairs same thing. And I need to return the same thing. I pull it all first floor store.
Okay, so the entire first floor is going to be the store?
Store only.
Okay, so
Second
no studio in the back?
No.
Okay,
No.
and what's in there right now?
Now it's empty.
It's completely empty right now?
Yeah, complete is empty. I can't do anything before you do decision.
Now, it shows that there's a kitchen that's in the back?
Yeah, kitchen and a bathroom, and in the back for the studio, and the store in the front.
Okay. So what's gonna happen with the kitchen now?
No, I leave it all. I be leave it a store and a bathroom, and I have to do like a daily grocery to pull it food and stuff like this.
Okay,
Whatever I take it off, no problem. Doesn't matter to me.
okay. So you're gonna leave the kitchen there?
Yeah, I want to leave a kitchen and a bathroom, and all the place be a store. But I have to carry food, stuff like this, like what you call it, like cheese, like stuff like this.
Are you planning on preparing food for sale in the kitchen?
As like what you call it, like salad, stuff like this, and
Cooked food?
no cooked food, only cold food, salad, sandwich, stuff like this, chipsies, all that stuff.
Any questions? No. All right, thank you.
Thank you.
We're gonna jump a little bit. 2017-291, 1321 Key Highway, Joseph Woolman.
Thank you, Mr. Chairman.
Good afternoon, sir. All right. Mr. Woolman, we have this as an application to use the premises as an open off-street parking lot. Is that correct?
That is correct.
All right. All those intending to give testimony can raise their right hands and be sworn, please.
Swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and truth?
I do.
Do we have staff reports?
We do. We received we received support letters from the Key Highway Community Association, the Riverside Neighborhood Association, and the Havana Management, all fully in support of this on August 11, 2017.
Mr. French?
Planning Department reviewed this application, noted that this property was originally designated as 1325 Key Highway. It has been subdivided into two parcels. One is 1325 Key Highway, which is the restaurant referred to as Little Havana. The other portion is this, subject of this application, which is referred to as 1323 Key Highway, and which the applicant is seeking to use as a surface parking lot. The problem in this situation is that the Key Highway South Urban Renewal Plan designates this property and the adjoining property as part of its mixed-use area, and the plan prohibits permanent surface parking lots in the areas designated as mixed use. On that basis, the Department of Planning recommends disapproval of this application, as surface parking lot use is prohibited at this location by the Key Highway South Urban Renewal Plan. Thank you.
Thank you. All right, Mr. Wallman.
Thank you, Mr. Chairman, members of the board. I have previously emailed a memorandum of law to the board, which is in your file. I'll introduce another copy at this time. For the record, regarding the paramount issue, and in interest of time, I'll proffer the majority of testimony, but my client is here, as is Councilman Costello, who's in support of this request, to answer any questions and add to anything that I may state. But to summarize the appeal memorandum, which gets into the law of conditional use, which I don't think the planning department is necessarily disputing regarding the applicability of the conditional use to the parking lot use. It's certainly permitted as a presumptive by right use under the code, and certainly given the support we've garnered, and there's support letters from the councilman, both community associations and the immediate neighbor attached to the memorandum, I would certainly make the argument, and it's supported in the memorandum, that the conditional use law is satisfied regarding that aspect of the request. With regard to the urban renewal plan, I think it's important to note that page 22 of the Key Highway South Urban Renewal Plan states, and I have a copy of it to introduce for the record as well, that no permanent, and obviously emphasize the word permanent, surface parking lot shall be permitted in areas designated as mixed use. This is certainly not the highest and best use of the property that we were requesting here today. My client paid a very large sum of money for this property and fully intends to develop the property. It is identified as a mixed-use site, and they fully intend to develop it as a mixed-use site. I've also attached the memorandum the preliminary plans they've already commissioned. They've spent a great deal of time and resources developing plans for the property. They do, however, wish to, in the meantime, continue to use what is now an existing surface parking lot. And I'll introduce that as the second exhibit, just the highlighted section from the urban renewal plan. Perhaps most importantly, my client, we've discussed this with the planning department as well, is willing to accept a condition from the board that this use be capped at 5 years. I think that certainly takes this request out of the permanent nature of what the urban renewal plan.
They're planning to move forward. Why do they need 5 years?
I'm sorry?
They're planning on moving forward. Why do they need 5 years?
Simply put, and I can have my client speak to this, they do not want to be forced to time the project in any potential market downturn. It obviously behooves them, given the investment they've made in this property, to move forward as quickly as possible. If, however, a change in the marketplace does take place, they don't want to be limited to building, if you will, in a downturn. So that's the reason for the request. Also, given the nature of this site, and the memo also addresses these issues, the site is located in the Chesapeake Bay critical area, in an IDA, the Chesapeake Bay critical area, in a waterfront revitalization area. There are a lot of moving parts in terms of the entitlements that are going to be required to move forward with what will be a significant waterfront development. Just the preliminary plans that we've attached, as you can see, are rather elaborate. So I think, as the board is well aware, it is going to take some time to wade our way through the entitlement process to the point where a shovel can actually be put in the ground.
I guess what I'm a little bit confused by, though, is just okay, so they bought a piece of property. They want to use it for something. Why are they here looking for permission to use it as a surface parking lot instead of just letting it sit there until they've decided to build whatever it is they're going to build
I
on?
think there's a few answers to that question. Number one, it's been used as a surface parking lot. Now, the previous owner may or may not have gone through the proper procedures to do that, and I think it frankly is a compliment, for lack of a better word, to my client in being forthright and coming to the board and seeking to have actual permission to continue what has been a longstanding use that is supported by the community. I think from a lending standpoint and from a financing standpoint, and there's also a closing between the buyer and seller of this property that is still pending. There's interested parties as to their ability to continue to use the surface parking lot to reap the revenue, possible revenue of the parking lot while they continue to prepare the plan for the development. And my client can certainly speak further to that aspect if that's not a satisfactory response to your question.
I'm somewhat familiar with the location in the parking lot. I'm familiar with it mostly being used as a site to sell Christmas trees.
I'm aware of that as well.
I haven't seen very many cars parking out. There's not like a booth and whatnot, and a guy up there taking tickets and all that kind of stuff.
And frankly, I think this request is an opportunity for the city to be able to have a say in that. And I will state, and you and I both live in the area, Mr. Chairman, and I actually have seen a lot of cars parked on the lot overnight, as you can imagine, when there's a lot of parking. And I can also tell you, and I was sworn in, that I think it was either last summer or the summer before, a representative of the planning department actually called Mr. Veal regarding this use as a parking lot. So it's definitely on the city's radar. I advise my client, and they frankly need to satisfy certain parties as they move forward that they can do this legally. And again, I would point out the language in the urban renewal plan clearly states permanent parking lot. And I think the reason it states that is exactly for this scenario. When you've got waterfront property, valuable waterfront property that my client paid, frankly, millions of dollars to acquire, and it's identified as a mixed-use site for development, the highest and best use there is not a permanent parking lot. And they certainly didn't pay this amount of money to have a parking lot there. That being said, I think the reason the word permanent is in there, and if you take a close look at the support letter from the Riverside Neighborhood Association, the author of that letter, and I know this for a fact because I also attended a lot of these meetings, was deeply involved in the drafting of this urban renewal plan. It was a multi-year process, and in her letter, she does state that she believes this type of request and capping it to 5 years and not having it a permanent parking lot as we prepare for development actually is in keeping with the spirit and intent of this plan. I think that's an important piece of testimony on the record before the board.
Well, obviously the planning department doesn't believe so.
I understand that.
And my understanding of their position, and Mr. French, if you could address this, but my understanding of their position is that the prohibition against surface parking lots is really to incentivize property owners to quickly get properties into a more developed state, and that the vision of the planning department, both with respect to the urban renewal plan as well as with the new zoning code, is really to squeeze out a lot of these surface parking lots and see those properties put to other uses. Mr. French?
Historically, this particular property, of course, was part of the larger property that belonged to the restaurant next door to it. And it's my understanding that approximately 4 years ago, when the subdivision concept was first floated, the owners were warned that if they did subdivide the lot, that they would no longer have the ability to use it for a parking space. It would no longer be accessory to the restaurant. And with that warning in hand, they proceeded to subdivide the property. So the question then basically before the board is, what is the distinction between a temporary parking lot and a permanent parking lot? And my understanding is that traditionally in Baltimore City, the zoning administrator has given temporary parking permits for usually up to 6 months at a time. But with the possibility of a renewal, maybe for an additional 6 months, but the idea being, yes, temporary is temporary, and asking for a 5-year period to be called temporary is quite frankly a bit much in the eyes of the planning department and inconsistent with the purpose of the urban renewal plan. And that's the reason the department is recommending disapproval of this application.
And obviously, we completely disagree with that analysis regarding the spirit and intent of the plan. And if the goal, per your own language, Mr. Chairman, is to foster the redevelopment of the site, then allowing this to take place and allowing my client to continue with their plan will work towards achieving that goal. I've had multiple conversations with the planning department regarding this issue. We have filed a pre-development meeting request at the planning department's request, and we are ready to move forward with the redevelopment of the site. Were this application to be denied, and again, I don't see the basis in the urban renewal plan based on its plain language to deny the request. I understand the planning department has its interpretation of what that may mean, but the planning department is not the authority on the interpretation of the urban renewal plan.
Well, yeah, I'm sure that you're familiar with the with the concept that regulatory agencies charged with enforcement of laws or regulations are given deference as to the interpretation of those provisions that they're charged with enforcing.
Certainly, it doesn't.
And
again,
so the planning department is the agency that's charged with enforcement of the urban renewal plans.
Understood. Again,
So
it's the board, frankly, that has the authority to rule on this request.
And just as it would be across the street, it would be up to the court there as well to interpret it. However, the court has to, as does the board, and to give deference to the agency who's charged with enforcement of these provisions. That doesn't mean their word is God, but it means that you have to give deference to what they're saying.
I think you're correct. I think you also need to give deference to the intention of the property owner here, the fact that they're willing to accept a condition to be placed on this approval. If we were not willing to accept that condition, I think the planning department would have a very strong argument regarding this urban renewal plan.
Well, do you really have a choice?
I'm sorry?
Do you really have a choice?
No.
If you refuse to limit it and said, no, we want an indefinite
Well, then,
right
if you look at the urban renewal plan, then we would be seeking a waiver from the Department of Planning, which is also clearly stated.
But you're not seeking that.
Because I don't believe it should be necessary. Given the fact that we're willing to accept the condition, rather than go through another process that frankly is extremely subjective, and attempt to obtain a waiver from the Director of the Department of Planning, based on my client's willingness to accept the limitation, I believe takes it out of the clear language of the plan itself. Permanent, and I wasn't trying to be glib, but I recited the definition of permanent in the memorandum according to Webster's dictionary. It clearly, the plain language is plain language, and I know this isn't a statute necessarily, although you could argue it is because it's passed by ordinance. I think the plain language rules regarding the permanency of the parking lot, and the fact that they're willing to accept the condition, the fact that at the planning department's request, we've scheduled a pre-development meeting, we clearly are moving forward to redevelop this property. If this were to be denied, then we would actually be working against the goal that you cited earlier, and that is to foster the redevelopment of this site.
Well, it's still lost on the whole concept of why you're seeking the permission to use it as a surface parking lot instead of just simply you bought some land. When you're ready to build on it, you'll build on it.
I'll defer at this point to my client as to the points I started to make regarding other parties.
Why don't you go right ahead?
Thank you. State your name for the record.
Hi, my name is Dan Goodyear with Goodyear Properties. Thanks so much for your time.
Goodyear.
Goodyear, Goodier. We own the property immediately across the street as well, where Planet is and Order and Chaos are. And in the meantime, as we are proceeding with development and coming up with a plan for what we want to develop here, our hope was to use this site for parking for that building. It's a revenue generator for us. It helps us with the financing side, as Joe said. Certainly, we have no intentions of keeping this a parking lot long term. If if I thought I could get through all the hoops and put a shovel in the ground next week, we would not be having this conversation. And we are working diligently to try to make that happen as soon as possible. Really, the hope is just that in the meantime, we can keep, because right now a lot of the people in the building are parking on the streets, which we've discussed with the neighborhood association. That's a big reason why they're on board with this, because they'll be off the street and for the meantime until we build structured parking for them there. So it's mostly a stopgap, really just something we want to use for the community to make sure everything's better.
I know that for a long time, parking for that complex had been at the Museum of Industry.
It still is, yeah. We have an agreement with them where we lease a number of spaces from them, and currently we're leasing spaces at in the Harborview lot. And this would just allow us to not be paying the Harborview people while we got our development projected and in order.
What do you intend to do with this lot during this parking phase? I mean, do you intend to blacktop it? Do you intend to put in automated machines? I mean, what do you intend to do?
Yes, sir. The plan would be to blacktop it and restripe it.
Is it blacktop now?
What's that?
Is it blacktop now?
Partially. There is some area that's not finished, so we were going to come through, blacktop the whole thing and restripe it and put an automatic arm in. Right now it's fine looking. But we're going to put money in just to appease our tenants in the meantime and secure it.
But what would be your plan if at the end of the sunset period, whatever that period is, market turns downward or doesn't progress to your satisfaction, then what happens?
Well, historically, and the way we're looking at the marketplace, we're extremely bullish on it, so I really don't believe that would be necessary. I think 5 years is an outside term that we feel very confident will be a down cycle and then ready for us to build again. If there was a prolonged down cycle and we weren't getting the pre-leasing that we wanted to do on the construction, I believe we'd come back and ask for a shorter term extension. But I really don't envision that as being an issue.
Would a shorter term sunset period be acceptable?
Mm-hmm. Absolutely. If that's what made the difference. And like I've said before, we are trying to get this built as quickly as possible, and I'd be more than happy to accept a shorter time period as long as it was something that protected us from having to build a building or sell a lot into a down cycle.
Mr. French, from the testimony that's been given, is there any, does that have any kind of effect on the planning department's, or would you believe it to have any kind of effect on the planning department's position, given that what's being sought here is really to operate a parking lot as accessory to, well, I guess it's really the across the street office use.
And additionally, just as another side comment, we have been in discussions with Little Havana that they use the parking lot for their special events and for evening parking, and we would continue that use for them.
Okay.
Quick answer is, as I am not the person who is assigned to this urban renewal plan, I would have to defer to the opinion of someone who is not present, namely the administrator for that urban renewal area. And secondly, of course, the department has never had an opportunity to approve or disapprove a temporary parking permit for this site, as none was never applied for, as has been testified. It's being operated illegally in the past as an off-street parking area. Therefore, I'm not in a position really to answer the question, simply put.
All right. Okay. Any further questions? Anything further, Mr. Bowman?
No, nothing further.
Councilman, do you have anything we wanted to offer?
Thank you, Mr. Chairman and Commissioners. Eric Costello, Costello, 11th District City Council. I would respectfully request your favorable consideration for this. I appreciate the fact that Mr. Goodyear, A, has spoken with the community, B, has come forward to try and ensure that he's doing everything legally on this property. C, has a development plan or conceptual development plan in front of you that he's pursuing. D, to keep in mind, the several entitlements that will be required because of the uniqueness of this property, because of the fact that it's on the water, and with community support and having worked with Mr. Goodyear in the past, I'm very confident that a development project on this site that makes sense for this area will move forward. Just the fact of Mr. French wasn't there, but the individual you're referring to, Mr. Flickinger, he and I met with the folks on Key Highway about 4 weeks ago over at Air St. Gross at the Tide Point campus to talk about efforts to beautify the Key Highway corridor. And this would certainly complement those planned efforts. So for all those reasons, again, I would respectfully request your favorable consideration, and I'm happy to answer any questions the board may have. Thank you, Mr. Chairman.
All right, thank you.
Thank you.
Take it. All right. 2017-271, 2745 Huntington Avenue, William Bauer.
Mr. Floyd.
Okay. All right, Mr. Bauer?
Mr. Shulman.
Okay. All right, what's your name, sir?
Nicholas Shulman,
All right. Got that?
Schulman?
Schauman, Shulman.
All right, sir, we have this as an application to use the first floor as a tavern that will have accessory live entertainment and outdoor seating, and the second floor as a restaurant. Is that correct?
That's not correct. We're actually first floor, second floor restaurant.
Sorry, I'm Will Bauer. Actually, the whole thing is a restaurant with a liquor license.
And I have a preliminary objection as well.
One moment, Mr. Armstrong. We can only speak one at a time.
Okay.
All right. I guess we'll get into this once we get into the testimony.
Right.
If all those intending to testify can please raise their right hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
All right. And do we have staff reports?
We received email correspondence from members of the RNA Association. However, since they are there, we'll defer their testimony based upon the letter we have submitted into the record for the case file.
Planning Department reviewed this application, which was described as indicated as a restaurant and bar with live entertainment and outdoor seating. Second floor of the premises to be used as a dining area. The department noted that the application did satisfy most of the conditions and provided responses to most of the criteria required for this type of application. The maximum occupant load authorized was stated as 99 persons. Live entertainment would end at midnight every day except on Sunday when it would end at 4 p.m. The application did not mention specific parking resources other than on-street parking and use of a nearby parking garage, and it did not provide beyond a doorman any on-site security proposal. Given the maximum number of persons who could attend a live entertainment event at this location, it would be appropriate to provide some off-street parking meeting zoning code requirements and an enhanced security plan. The Department of Planning therefore recommends that approval of this application, if granted, be subject to conditions that the applicant provide off-street parking for patrons of live entertainment events and that there be adequate on-premises security during those events. Thank you.
Thank you. All right, and gentlemen, are those conditions stated by the planning department acceptable to you?
Yes, sir.
All right. Now, who's going to be speaking as the applicant?
I will do most of the speaking.
Okay, because it seemed like Mr. Bauer wanted to clarify as far as the intended use, and you both were sort of arm wrestling over what it was you're proposing. So why don't we start off with that?
Okay.
And we're going to ignore a preliminary that.
No, Mr. Armstrong, we're not. We're trying to figure out what's being presented. If you can wait to be called, please, sir.
Fine, thank you.
So myself and my business partner, Patrick Hudson, we're owners of the local oyster in Mount Vernon Marketplace. We have a seafood oyster bar. We're partnering up with Mr. Rob Macy here, and we'd like to open up a Gulf-inspired seafood oyster house at the address on Huntington Avenue. And we would like to, we're here asking for live entertainment because Mr. Macy here is a DJ. And our plan, our idea for this restaurant is to combine the food and the music of the Gulf culture in Baltimore and create an environment where neighbors can come and get a good meal and listen to some music and meet with the neighbors.
Okay, so what's going on the first floor? As I said, we have that as use the first floor as a tavern that will have accessory live entertainment and outdoor seating, and the second floor as a restaurant. When I look at your application, appeal information, use entire first floor as a bar restaurant with live entertainment. Bathroom, outdoor seating, 4 tables with 16 chairs, second floor dining, and 2 bathrooms with basement for storage.
Mr. Chairman, if I can, my name is Will Bauer, B-A-U-E-R.
Yes, sir.
I'm not sure where the word tavern ever appeared. We never actually put the
Well,
word.
because you said bar restaurant.
Sure.
So the only concept of bar restaurant recognized under the zoning code is a tavern.
Sure. So it's definitely going to be a restaurant that has a liquor license, so it's not going to be a tavern per se, but it's definitely going to qualify for the restaurant liquor license that Baltimore City offers.
Okay, so is this going to be like, is the entire thing going to be one establishment, or are there going to
Yes.
be 2 separate floors? Okay.
Yes, sir.
Okay, so there's going to be, okay, so it's going to be one establishment,
Yes, sir.
primarily with dining on the second floor,
Exactly.
and with a bar and food area with live entertainment on the first floor,
Exactly, and outdoor seating also is on there.
with outdoor seating. Okay.
Sorry about that, the confusion.
That's fine.
And one entity will own the entire establishment, so there won't be separate companies owning the first floor and second floor, it'll all be one owner?
Correct. It'll be owned by Second Line LLC.
Okay, all right. Mr. Armstrong, you had a preliminary matter you wanted to raise.
Yes, it did. And I don't know if, there was one copy given to the board. I don't know if you all have a copy. I have.
We have nothing.
And this is protestant's preliminary objections from Ted Hedricks, who is at 2709 Huntington Avenue, Peggy Matthews, her property owner at 2810 Huntington Avenue, Romaine Johnson at 2652 Huntington Avenue, and myself at 2828 North Howard Street. We move this board to dismiss appeal 2017-0271 to reject an incomplete application, postpone the hearing, and/or grant other appropriate relief based on the following points. C1 zoning on this property is not final. The C1 zoning, is it C1, is it B1, is it R8? The C1 zoning on this property is currently under challenge as part of a taxpayer suit that alleges the new city zoning map was not lawfully enacted.
Is there any sort of injunction issued by the court?
No, there hasn't been, but there is a court case that is going forward on that.
But the court has not ordered.
No, it hasn't, to my knowledge, all right? That's Baltimore City Circuit Court Case 24C-17-003021.
There's a presumption of constitutionality and proper enactment with statutes and laws.
I'm not going to go legally there. I just know that that's what it is.
So,
The previous rezoning of this property was to B1, under which a tavern use is not authorized and a restaurant use has a minimum off-street parking requirement, remains under challenge in two related cases now pending before the Court of Special Appeals. Number 01178, September term 2016, and number 00550, September term 2017.
My same question, any injunctions issued in either one of those cases?
No. Under the property's prior R8 zoning, neither a tavern nor a restaurant use may be established, and live entertainment is prohibited. So, under C1 zoning in Article 32, the application is incomplete and ambiguous. Section 5-201B2, an application for a variance, conditional use, use permit, or zoning appeal must be filed by 1, the owner of the property to which the application applies, or 2, a person expressly authorized by the owner in writing. This basic application requirement was not met. The owner of 2745 Huntington Avenue is Roberts Norris Realty Development, LLC, an entity that was declared forfeit by the state of Maryland in October of 2015. Exhibit A on your packets. This application was filed on June 29th, 2017. At that time, it was impossible for the owner to request a zoning authorization or to provide any written authorization for others to do so. Moreover, there is no evidence of express written authorization for the June 29th, 2017 application. There is only the statement of William Bauer declaring to have received specific approval of the owner to act as agent for this application. See Exhibit B. The statement is not credible as the owner was a forfeited entity unable to conduct business in Maryland. And you can look at sections 5-201C3 in the zoning code, 5-201E1, and 5-201C4. These basic application requirements were not met. All required information, plans, and data were not provided with the June 29, 2017 application. The inadequacy of the application speaks for itself. And I also have email correspondence between Ms. Floyd and Mr. Schuman here with specific questions about that, and I will proffer those to the board as well, listing the ambiguities and inconsistencies and requirements not met on the application, some of which I think you've already started to look at. But these basic application requirements were not met. Drawings submitted with the application lacked the measurements and did not identify features. Information is missing from the live entertainment portion of the application. No site plan was submitted with the application. In lieu of a complete application is the statement of William Bauer declaring the submitted materials to be a true, correct, and complete statement of the work covered. See Exhibit B. The statement is not credible as the application was incomplete on its face. Ambiguities and inconsistencies for what are the requested conditional uses. As stated above, the application is incomplete and should not be processed by the zoning board. Also, the use request is ambiguous. The application and materials in the file indicate or suggest that tavern, accessory live entertainment, and food processing light, in other words, catering, are the requested conditional uses, while restaurant and outdoor dining are also identified as proposed uses. It is not possible for the board to consider all of these uses together. For instance, to ask for both a tavern and a restaurant is to nullify the application. A tavern use which requires no retail food sales, and a restaurant use which has a minimum requirement for retail food sales cancel each other out. If a tavern is approved as conditional use, then by definition the establishment is not a restaurant. Also, outdoor dining is not allowed as accessory to a restaurant, but not to a tavern. Moreover, it is questionable whether an applicant maintain both a restaurant and food processing light on the same premises, as the non-retail food sales from the latter cannot be counted toward the minimum food sales to sustain a restaurant use. And finally, food processing light is not mentioned on the sign posted on the building, and as a result, these ambiguities and inconsistencies, the application should be denied. The applicant should be required to reapply at a minimum, and the applicant should be required to correct the misleading application, reschedule the hearing, and post a new notice. That's our request.
Given that I for a few different reasons. First of all, there's no injunction as to the effect of the zoning code. Second, as to the claim of the, I guess regarding the lapse of the corporate formalities for Roberts Norris Realty Development LLC. While it certainly appears that that entity does have is not in good standing, that entity is not before us. The applicant here is Second Line LLC.
But is it not required of your application that the property owner, in this case, the property owner of 2745 Huntington Avenue, has to be a legal entity able to, you're saying that part of the code doesn't apply? Okay.
Because what it says is that the application must be filed by a person expressly authorized by the owner in writing. The applicant here meets that requirement. They're not doing the fact that that the property owner gave the applicant the right to file this application and, I'm guessing, purchase the property from them does not affect the applicant's application. As far as the part about tavern versus restaurant, outdoor dining, and all that ambiguity, we already got that out of the way before we took up your motion.
So you're allowing them to amend it on the day in front of you without an application to be reviewed or looked at or analyzed?
No, I am not. I am deciding what I am deciding.
Okay.
Okay? I asked them to clarify what it is that they are proposing. They did that. The part that made it confusing is the fact that there are different references to different types of uses on different floors, giving the impression that there are more than one establishment. They have said that that is not the case, and they have clarified the fact that it is one establishment with dining on the second floor and food and bar on the first floor, all one establishment, not multiple establishments. That doesn't make it a tavern. It's a restaurant with a bar. Okay. Motion's denied. All right. Mr. Bauer, Mr. Schuman.
Yes, sir.
All right. Why don't you go into what you're proposing here, sir? And also, if you can address the deficiencies brought up by the planning department regarding the lack of parking plan and security.
Okay. Yes. Go for it. So could you repeat the question, sir?
I said,
Okay.
first, if you could just tell us what it is that you're proposing. So
Okay.
you can walk through your vision for the establishment. While you're in the process of doing that, if you can also address the concerns brought up by the planning department regarding the lack of parking plan and the absence of security.
Okay. So we are committed to opening this restaurant. My business partner owns an oyster farm. Our oyster bar in Mount Vernon has been very successful. We've won a couple awards because we are really focused on our seafood. We think that seeing everything that's going on in the Remington community would be a great place for us to open up and, create a space that's good for the neighborhood. Currently, the building right now is a vacant building. It's been vacant for about 10 years. We're working with the folks at GRIA, and Seawall are helping us out. We're actually in the process of working with the state to get historical tax credits. So our plan is to bring the building back to its original state and beautify the neighborhood at the same time.
As far as parking goes, we've spoke to the folks at Seawall. There's a letter in there that has granted us permission for our customers to park at the parking lot at Remington Row. We've got a letter of support from Councilman Stokes. We have a letter of support from GRIA. We've been awarded a facade grant for $17,000 to add planters and clean up the street. What else am I missing, guys? Oh, we also attached to the packet, we have 234 signatures from Remington neighbors who are in support of us opening second line. And as far as the communications with RNA goes, we originally filed to do this in February. And I met with Mrs. Floyd back then, and she showed some concerns, and we agreed that we would postpone our trial so we could adjust and amend this application. So in, I believe it was June, I think you can see on page 25, it was when we submitted our second application. And I reached out to Mrs. Floyd 2 times, hoping that she would sit with us and go over these application and any problems she had with it. And that was a couple months ago. And I just started getting the emails from her last week that she had all of these issues. So our thought is that, you know, if something could have been addressed, there would have been plenty of time to do it, except, you know, not the day before our trial. Other than that, you know, we're all born and raised in Baltimore. We love the city, and we just want to see Remington neighborhood grow and flourish, and hopefully we can be a part of it.
With the live entertainment, why don't you go into that?
Okay, so as I mentioned earlier, our third partner in second line is Rob Macy. He is a DJ that specializes in mid-century soul, funk music. He's been voted best DJ in Baltimore a couple years in a row. And pretty much, you know, in order to have a record player, if you will, we need a live entertainment license. Our plan is not to have a stage and bands and dance parties and all this craziness. We just want to be able to play records while people eat dinner. So that's really why we're here. I'm sure there will be special occasions. We intend to have a piano in the bar, so we would like to do jazz and blues piano, live jazz and blues piano for happy hour from like 4 to 7, and possibly have some brass or jazz bands play for our brunch, where we hope to do on Sundays.
Okay.
So live piano for happy hour, records being played during dinner, and you know, an occasional live show, depending on who's in town or, you know.
Okay. Any amplification going along with this?
There will be speakers, but the contractor we're working with, we will be installing soundproofing on the exterior walls of the building. And due to the regulations of the historical tax credit, I think we have to leave our front bay windows in place. They don't open. So the windows won't be open. We will have soundproofing. You know, again, it's music to dine by. Also, we plan, you may be able to see it on the after rendering. We plan to put in some planters with some greenery between our building and the neighbor's building, as well as along 28th Street, and to hopefully use that as a sound barrier and just to create a dividing line between our space and the rest of the street.
Okay, because you can understand that there's significant, well, there may be significant concern from your adjoining residential neighbors about sound.
We do understand that.
And do your, I have to flip through them again, but do your submitted, your supplement here, does it go into any of the soundproofing that'll be employed?
No, I did not include any of the soundproofing, but it is clearly stated on our quote from Atlas is the contractor that we'll be using. So I could surely get you guys a copy of that if need be.
Probably be a good thing.
Okay.
Now, the planning department had concerns about parking and security.
Correct. Well, again, there is a letter from Mr. Tebow over here from Seawall that we can use the parking lot at Remington Row. We will be installing bike racks. We will encourage local foot traffic and Ubers. A lot of people are doing that nowadays. As far as security, you know, we intend to be a restaurant with music. We don't really see a need for security at a restaurant while people eat. However, as
you said
mentioned,
you were going to be periodically having events.
every once in a while, depending, we could have a live entertainment event. And if that's the case, there are security companies that we could surely call and have a door person. Yeah.
Also, can also offer special event valet.
Special event valet, that's right.
Where would that be?
The zone would probably be out front on the 28th Street side, and the lot, the same lot being used from Remington Row would be where the car would be brought to. Under the city offers that on a temporary basis for special events, as opposed to a long-term.
There's, seems to be question in your package here about whether or not you're gonna be equipped to operate as a restaurant. Could you address that? Whether you're gonna be equipped,
Equipped.
full kitchen.
Your full kitchen on the plans.
Oh, yeah. We do have a full kitchen on the plans.
Page 13.
Page 13, the bottom right quarter of the first floor is the kitchen that you're looking at. We've already been working with Acme Company, and we've got a full equipment list, and we have submitted that to our contractor, who's going to make sure that all the permits are pulled and all the receptacles and plumbing are in its place, but we will have a full kitchen on the first floor.
Here's a little more detail.
It's a bigger copy.
got this area where you've got the planters and the fence going out on the sidewalk.
Yes, sir.
You know, you'd have to get a permit for that.
Yes, sir.
Okay. Just wanted to be clear.
But in order to, apply for that permit, we would need our outdoor seating license.
You'd need outdoor seating, yes.
Yes.
But you wouldn't need permission for outdoor seating necessarily to have the minor privilege to work the planters and the fence.
Okay.
But I guess the one thing that I'm having a little bit of problem with is your suggested days for live entertainment. You said that you wanted to have piano player during happy hours.
Non-amplified.
Obviously, it's a piano. Although I guess maybe you could have a microphone with the person singing.
Right.
So the piano for happy hour, a brass quartet for brunch.
Possibly.
A DJ playing music during dinner, and occasionally, depending on who you can book, some bands or musical acts.
Right.
So the form that we use for live entertainment really requires like a schedule. So it doesn't really allow for, because anything that we write up, we have to say, what's permitted on what days, et cetera.
Gotcha.
So having something that's just sort of amorphous, like, well, whenever we can get someone, it doesn't really fit into that.
Right.
So if you wanted to maybe have, it might be better to have maybe certain designated days. And looks like you're looking to do live entertainment every day of the week. So your happy hour will be every day from 4 to 7, you said, and then
4 to 7, and right now, we're not planning on being open on Mondays.
okay.
Okay. And, again, with the DJ, the technical word for a guy playing records.
Yes.
There is a list of musicians in here that Rob will base the sound of the restaurant. And it's, musicians like Louis Armstrong and the Meters and the Pointer Sisters and, Little Richard. It's not... We're not planning on throwing massive parties.
Yes.
It's just a technicality between the difference between playing Pandora and playing the same music on vinyl.
Okay. And the decibel restrictions you'll have to abide by?
Yes, sir. I think it's, we've applied for 80 decibels.
40 to 80. That's measured at any point 10 feet from your structure.
Correct. So with the soundproofing and the closed windows, that shouldn't be an issue.
Okay. Anything further at this time?
Anyone?
Anything about the deed or the letter from the owners of the property?
Oh, we're good. May?
Yeah,
You want to come forward to the microphone there?
good afternoon. I'm Thibaut Manikin with Seawall Development. We've done a lot of work in the Remington neighborhood. It's amazing that these corner properties that have been vacant for, at some points, decades, are having new life breathed back into them. So we think it's an amazing fit. One of the reasons that we built 260 parking spaces in the garage that's less than a block away, which is a public garage, was to encourage other businesses to be able to open and do things like Second Line's talking about doing. So we're fully supportive of this, and we think it's a great use for the community.
Yes, ma'am.
My name is Winona Engelpratt, last name ENGLE-PRATT. I'm a representative of the Greater Remington Improvement Association. I'm the secretary of the Land Use Committee. We would like to note that the applicant has gone through all of the formal processes for our association to gain approval. They have been at multiple land use committee meetings and general body meetings, and we have voted to approve unconditionally this application. It fits with our draft community master plan, which seeks to revitalize these corner stores and see more small businesses moving into our neighborhood. And we are delighted to have yet another Baltimore-based small business moving into our neighborhood. Thank you.
Thank you.
Hello, my name is Laura Schneider, and I'm here representing the staff and clients of Fringe Baltimore. It's the business across the street from where this is supposed to be going in. Everybody has been overwhelmingly positive about this business moving in. Our clients have been rushing to sign the signature form, and we're really enthusiastic about supporting it. Thanks.
Thank you.
My name is Bill Cunningham. I live in Remington, and I've owned properties there for 17 years. I own the property directly across the street from this. It's a commercial property that's been vacant for some 20 years, and one of the reasons that it's been vacant, as well as the property across the street, is the protestations, obstruction things that happen because of the gentleman standing beside me continually tries to keep our neighborhood from advancing. I also own 2815 Huntington, which is 8 doors away. I have no objections to this. It gives us more eyes on the street. We have drug dealing that goes on across the street. We believe that business being occupied, and then my business across the street, and possibly in 2018, will help to move those drug dealers off of that street. It is something that we really, really need, and really sorry that some people continually try to keep us from advancing. At our general meeting, there were over 40 people attended that meeting. Only one person voted against, Mr. Hendricks, and possibly there was an abstention. The community overwhelmingly wants this. It is going to be wonderful to walk the 3 blocks from my house to be able to go and get oysters. I don't drink, but I'm going to go get some oysters. And I do enjoy that type of music also. So thank you.
Thank you. Sir? Okay. Mr. Armstrong?
I was wondering, I realize I would like to ask Mr. Manikin a question about the authorization.
If you can
Remington
call
Road.
whomever you'd like.
Tebow, if you come back.
Manikin.
Since I've not seen the letter that has been presented to the board, what exactly is the authorization that you're offering to Second Line?
Well, it's a public parking garage, and they're more than welcome to park there.
So they're not talking about them buying spaces and comping people's tickets?
There's no prearrangement for set-aside spaces.
Thank you very much. That's all I need. All right, then. I have Mr. Hendricks, who is here to speak on behalf of adjacent nearby neighbors, and I have myself speaking as well as for neighbors, but also in the some of the legal issues that I also want to put forth to the board. Who would you rather hear first? Rather get me out of the way, wouldn't you?
It's really up to you to present it however you'd like.
Ted, you want me to go first, or you want to go first? All right, then. I have a couple of things, if you could just hold that up for them, and I'll point to it. As you can see, this is the subject property. This is a 300-foot circular line. These are all of the residential blocks that surround the property. 2700 block of Huntington Avenue, east side, west side. 2800 block, west side, east side. 28th Street, north and south. You've also got a 400 block of 28th Street as well. I want to submit the following points and authorities in opposition to this conditional use application. Article 32 on conditional uses, Section 5-401A, quote, "This code is based on the division of the city into districts in which the uses of land and structures and the bulk and location of structures in relation to land are substantially uniform. Certain uses exist, however, that because of their unique characteristics cannot properly be classified in any particular district without consideration, in each case, of the impact of those uses on neighboring land and of the public need for the particular use at the particular location." Prima facie incompatibility set forth in Article 32. 2745 Huntington Avenue is surrounded by row houses. Exhibit E, which is this, and I will tell you what. There are two packets of exhibits. which I will start. So Exhibit E is a copy of this display board. The commercial uses that are considered compatible with residential uses are identified in Article 32 at Section 12-1003, which describes the row house R-MU zone. In the R-MU zone, that's residential mixed use, quote, "Commercial uses are restricted to only those uses that are compatible with residential uses," end quote. It's section 12-208 and 12-1003. Neither tavern nor accessory live entertainment is on the list of compatible uses. This is in the R-MU zone. In other words, taverns and live entertainment are recognized in Article 32 as being prima facie incompatible with residential uses on row house blocks. The comprehensive master plan, Baltimore City's comprehensive master plan, does not recommend establishing new nightlife uses such as taverns and live entertainment on row house blocks. The Schultz v. Pritz test for conditional uses, special exceptions. I'm going to quote, Maryland's Court of Appeals has stated and reiterated, quote, "The appropriate standard to be used in determining whether a requested special exception use would have an adverse effect and therefore should be denied is whether there are facts and circumstances that show that the particular use proposed at the particular location proposed would have any adverse effects above and beyond those inherently associated with such a special exception use, irrespective of the location of the zone." Turner, 270 Maryland at 554 through 55, 310 Atlantic 2nd at 550 to 51, Dean, 240 Maryland at 330 to 331, and 214 Atlantic 2nd at 153, Anderson, 23 Maryland app at 617 to 618, and 624 to 625, and 329 Atlantic 2nd 2D at 720 and 724. And that's the end of the quote from Schultz v. Pritz, 291 Maryland, 122 through 23, cited in People's Council of Loyola, Maryland, 406 Maryland, 54. Inherent adverse effects of a tavern and accessory live entertainment. The adverse effects ordinarily associated with a tavern and or accessory live entertainment include regular noise and activity of late-night business operations, patrons waiting on the sidewalk for entry to entertainment, nuisance behavior of inebriated patrons being noisy, disruptive, inappropriate, like public urination, and even destructive vandalism upon leaving establishment. Noise of staff closing establishment late at night, including filling dumpsters, taking out the trash. Noise of patrons walking to and from their parked cars or other destinations. Noise of entertainers loading equipment into establishment and back into vehicles. Loss of street parking to accommodate loading of entertainers' equipment. Increase in patrons' cars needing parking spaces. Increased parking congestion and competition for street spaces. Noise and noxious odors from patrons smoking and talking outside the establishment. Sounds from entertainment audible from adjoining and adjacent property and the street. Victimization of patrons. Increased street robberies and related crimes of opportunity. Altercations involving inebriated patrons. Damage to property, including cars. Impaired driving. The extraordinary adverse effects of a tavern and or live entertainment establishment become extraordinary when the establishment, as in is this case, is adjacent to or surrounded by row house neighbors.
Well, if I may interrupt you for a moment, Mr. Armstrong. As we clarified when we began, what's being proposed isn't a tavern, it's a restaurant. It's a restaurant that has a bar inside of it, like several different restaurants typically do. But I think that it's appropriate to make sure that we're being accurate with our phraseology here. Because while you're characterizing the establishment as essentially being a bar, that's not really what was testified to.
I understand that, but I am also working on the fact that the sign on the front talked about a bar restaurant. Correct? That is.
Talked about.
That's what the sign says, bar restaurant.
Talked about, to my understanding, it talked about a bar being on the first floor with a restaurant on the second floor. The implication is that it's two separate uses, but that's actually not true. What has in fact been testified to, and what we're considering here, is a restaurant that has a bar associated with it.
And I'll say this, that was what was given to you at the beginning of this hearing. That is not what was given to people who walked past.
If you can try to conform your arguments to the facts.
I'll tell you what, I will take that, I'll take that under advisement, and I will finish my statement so I can get it read into the record, and then you have it all, and everyone can know the lay of the land. The established residential use and enjoyment of adjacent and surrounding properties will be significantly and negatively impacted and disrupted by the adverse effects of these uses. The noise and other disruptions caused by late-night operations will adversely affect the ability of residents of all ages to obtain essential, healthy sleep needed for success in their daily life as students, workers, caregivers, etc. Patrons waiting for entry to entertainment will be immediately outside people's homes. Residents' front steps, fences, and gardens will be in the direct firing line of disruptive, inappropriate behavior by inebriated patrons upon leaving the establishment. Patrons walking to and from their parked cars or other destinations, rather than being confined to a commercial area, will walk past rows of houses. The smoking and conversation of patrons outside the establishment will immediately impact near neighbors. Some residents will hear the establishment's entertainment, possibly for hours at a time and on a regular basis. Some of the increased crimes of opportunity will take place along residential blocks, in front of or behind people's homes. Residents' cars may be damaged. The parking spaces lost to entertainers' loading needs will be spaces currently needed and filled by residents. In the evening and at night, residents will be unfairly forced to compete for on-street parking spaces with patrons of a busy nightlife establishment. As a result, residents will park further away from their homes. This in turn will increase the potential for residents to become victims of street robberies and related crimes. This specific impact being experienced now in another city neighborhood is the subject of the July 30th, 2017 newspaper article from the Baltimore Sun, which is Exhibit F. Incompatibility based on residential zoning of surrounding row houses. The properties in the area surrounding 2745 Huntington Avenue are not only residential in use, but they are also residential in their zoning. This goes to the use of the property board. Residential in their zoning. Because of this restrictive residential zoning, negatively affected property owners in the area immediately surrounding 2745 Huntington Avenue will be unable to change the use of their property as an adjustment to the adverse effects of the proposed conditional use. This is an extraordinary adverse impact on those properties. Historical incompatibility of nightlife uses in this particular location. For many years, the residential neighborhood has acted and advocated to prevent the corner properties in this location from becoming late night or nightlife uses. First, neighborhood residents played key roles in two highly significant achievements of the early 2000s, the permanent closing of the non-conforming and blighting Hard Times Tavern at 2740 Huntington Avenue in cooperation with the Health Department and Liquor Board, and the permanent closing of the non-conforming blighting tire store at 2745 Huntington Avenue in cooperation with the District Court. Since those significant events, there have been several zoning appeals, and each time this board has ruled so as to prevent intensive late-night or nightlife use of these corner properties that would be disruptive to the surrounding residential neighborhood. In 2007, Appeal Number 594-05, this board authorized a delicatessen use at 2745 Huntington Avenue on the first floor only. That's Exhibit G in the packet, okay? That's this board's decision in 2007. Was never utilized and never appealed, but that's what you gave them, was a delicatessen. Earlier in 2005, Appeal Number 46505, this board authorized a restaurant use for 2740 Huntington Avenue on the first floor only with hours of operation limited to 10 p.m., Exhibit H. That authorization was given to Mr. Cunningham, who never used it, never appealed it, never came back to ask for anything differently. It was his decision, his choice, to leave his building unoccupied and unused. It's not vacant, it's unoccupied. More recently, in 2013, on Appeal Number 2012-530, this board authorized a grocery store and delicatessen use of 2800 Huntington Avenue on the first floor only, with hours of operation limited to 10 p.m. None of these decisions was ever appealed. The relationship of 2745 Huntington Avenue to the intersection and the parking condition in the area are Exhibit J. And I have a couple of, two other things that I just want to bring to your attention. And thanks.
Back to our earlier conversation, sir.
Sorry, I want to bring your attention to J, which is the front of the sidewalk area where the table service would go. And K is the park, which is listed in the application as there being no public park. That public park is less than 200 feet away and has been there for years and was put into place and made happen by residents, local residents. So in spite of the statement on the application, the public park is there, and that is, for lack of a better word, a misrepresentation on the application, again, supporting my assertion that it should be returned to them and they should correct it and come back with a full application of what it is they're doing. Thank you very much. I will tell you what. I'll give you that statement for the record as well.
Thank you, Mr. Chairman, committee members. I'm very happy to learn that this question of what will be operating at 2745 Huntington Avenue has been resolved. This will be a restaurant with all of the limitations that designation implies. May I ask Mr. Bauer a question? Mr. Bauer, will the business be operating as a restaurant the full time it is open, including up to near 1 o'clock in time?
Yes, I'm Mr. Bauer. That's Mr.
Sorry.
Shulman.
Oh, sorry.
That's okay.
Yeah, so we'll be operating as a restaurant until 1 o'clock or whatever the reasonable
Correct.
cutoff,
We will have
reasonable cutoff time.
a raw
Very
bar,
interesting. Mhm.
serving oysters and clams.
Okay. All right,
And
thank you.
things associated with a raw bar.
All right, thank you. So anyway, I'm relieved this is not going to be a tavern. However, I'm not satisfied on the issue of the parking. My own guess is this is going to require another 38 cars in the, looking for parking spaces on the street during its opening hours. I'm not convinced by Mr. Shulman and Mr. Shulman's claim that significant number of patrons are going to come from the immediate neighborhood. Anyway, I have some problems with the live entertainment, as Mr. Shulman's application describes it. The application does propose a DJ and a piano player. He also mentions special events that will require security personnel. Also mentions showcasing local bands. Let's talk about bands, suggesting amplified music. Again, this property abuts one house directly. It's 12 feet from another. The reference to having special events on 28th Street baffles me completely. That's the very narrow sidewalk along there. There's no open space there. I point out that it seems to me that what Messrs. Schauman and Bauer are proposing is actually a destination establishment. It's not a neighborhood. We talk about showcasing local bands. Again, you're talking about something that's going to be intended to attract customers from outside of the immediate area. Its concept itself is a destination concept. This is not the kind of restaurant where people are going to eat several times a week. And in fact, there's no evidence at all that the immediate neighborhood is going to patronize this restaurant routinely. There are 130 row houses in that 300-foot radius. 75% of them are rental units. Probably the majority are low income, a significant number disabled or elderly. Finally, say that the applicants maintain that their objective is to revitalize Huntington Avenue. It's far from clear that Huntington Avenue's vitality ever depended on bars and restaurants. Certainly the history of the taverns in the neighborhood suggests otherwise. It seems to me revitalizing Huntington Avenue is going to come about because people are going to buy houses, improve them, and live in them, not by turning this into a entertainment destination district.
Don't forget to put the letters in.
Yes, and I do have I have letters from 7 homeowners, some in the within the 300-foot radius, some inadvertently outside, and they're distinguished in there.
Have a copy of what you just gave? Did you?
No,
There may be multiple copies.
Yeah, that's what it looks like.
Yeah. The top one should be
Yeah.
all originals, and then there should be. By the way, we'll take the pink ones on the bottom.
Is it 4, Jeff? 4 pages?
Yeah. Here's a new one. Here's new signatures. Oh, these are the letters from outside. Okay, I see.
So we can get just one set.
Okay.
One, the pink set should be, all the pink should be one set.
You said you needed all yellow.
My apologies, I didn't notice.
That's
I
okay.
wrote them out.
Okay, anything else you want to say?
For the record.
No, thank you very much.
If you guys want to look at those. Okay, is that it, gentlemen?
Yes, thank you.
All right. Mr. Schuman, Mr. Bauer?
Yes, sir.
I didn't know if you, well,
Closing?
yes, closing, response, anything?
We
You
want to
don't-
thank you guys for having us and hearing us, and, just to reiterate, we just want to play records at our restaurant. So hopefully, what am I trying to say? Well, sorry.
You did great. You're going great.
Been
You're
a,
going great.
been a long one. No, again, thank you very much for having us. And hopefully you will consider our application.
You passed this up at the beginning. There are emails, I guess, that were exchanged that are included as a part of it?
Yes, sir.
And there's, I guess it looks like you received an email on August 10th from Ms. Floyd. Nick, are you asking for a quote-unquote restaurant which will require you to maintain a minimum percentage of average daily receipts from food, or a tavern which does not have a minimum food requirement? Question mark. There is ambiguity in the application on this issue. Even the sign posted on the property is ambiguous. Signed, Joan. Do you recall that email?
Yes, sir.
Do you recall whether you responded to that email?
This was at the point where I did not respond.
Okay. And did you respond maybe on the next day? Maybe if you turn to page 29.
10:29. Yes.
Your email will say, "Hey Joan, sorry, I'm just getting this. As you can imagine, summertime keeps me very busy. So yes, this is very simple to clarify. We will definitely be operating as a restaurant with a liquor license. My apologies for any confusion." Do you recall writing that?
Yes, sir.
Okay, so suffice it to say, you advised Ms. Floyd on the 11th that what was being applied for was a restaurant with a liquor license?
Yes, sir.
Okay. Any other questions? All right. Thank you all.
Thank you very much, guys.
Thank you.
We're going to take a short break. Take a 5-minute recess.
Our executive.
On the record, we're going to call 2017-278, 1923 Ashland Avenue. Nate Prettle. Afternoon, Mr. Berry.
Good afternoon.
We have this as an application to construct a 5-story office building for Johns Hopkins Federal Credit Union at this location. Is that correct?
It's actually a 7-story building. I'll get into that.
Okay.
Cover that with your staff.
All right. If all those intending to give testimony can raise their right hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Do we have staff reports?
Planning Department reviewed the application that was made available to it at the time, noted that this application contained no dimension drawings for the building itself, and no dimension site plan for this property. This is a vacant lot, and this is a proposal for new construction on a vacant lot. The department believes that the applicant should provide to the board and to the department, because this property is located in the Middle East Urban Renewal Area, a dimensioned site plan and a dimensioned set of floor plans for this building for the purposes of establishing first whether there would be variances required of the setbacks required by the zoning of the property, and secondly for the purpose of determining how much parking variance may be required. As this is a new construction building, there is the possibility of including on-site parking within the design of the building itself. The department therefore recommends deferral of a complete hearing of this application to allow the applicant time to provide approvable floor plans and an approvable site plan for the proposed office building, including its off-street parking facility and any other relevant supporting features, and for the department to evaluate those plans in the context of both the zoning code and the Middle East Urban Renewal Plan design standards, which in turn would facilitate establishing the amount of variance of off-street parking standards that the board would need to approve. Thank you.
Thank you. Mr. Berry.
Mr. Chairman, members of the board, Al Barry, AB Associates. Here with me is Michael Mestos, president of the Johns Hopkins Federal Credit Union, Adam Tawney, who's the architect. And I want to, first of all, pass out to the board letter dated today, and more importantly, an aerial photograph that provides the context of this proposal, which you will hear is a headquarters building for the credit union. They now have 2 locations, one nearby in East Baltimore and one on 33rd Street, and I think the Eastern High School. And they're going to be consolidating their employees into one location at the Hopkins East Baltimore campus. And I discovered the planning department's position on this yesterday. So I'm glad to maybe clarify through that letter what is being proposed. Prior to June of this year, the property was in a residential zone, but the city, in its wisdom, zoned this property as well as, a number of other properties east and west along Ashland Street into a new zoning district called the Bioscience Campus. And the Bioscience Campus was really designed for the EBDI Hopkins Research Campus that you can see. And if you look at your aerial photograph, you'll notice a number of buildings that are immediately adjacent to this proposal. One building directly across the street, which is relevant, is a 7-level parking garage. The credit union has a long-standing relationship with the garage at Hopkins for their employees, thereby meeting any parking standard that would be required. There is a 20-story residential building showing up on your aerial block away, and there is a 7 or 8-story research building directly across the street as well. Since the application was filed, the application was not scaled, but it was always been at a height of approximately 85 feet. The new zoning district has a height limit of 150 feet, so we're well within that. And the new district has only setback requirements where the building adjoins a residential zone. In this case, the building adjoins where any setbacks would be required. Another campus district, the Bioscience Center at the rear, if the property will front on North Washington Street. So that variance goes away. Also, since the application was filed, and just last week, the credit union purchased the adjacent row house building on Washington Street. And that row house building will, in effect, be consolidated with the property and provide the 10-foot minimum setback requirement for the interior side yard. The planning department has pointed out, and we have no objection to, their further design review by the UDARP, and we look forward to scheduling that, hopefully with the board's approval today. Maybe Mr. Tawney and Mr. Mesta can tell a little bit more about their proposal. This is about an $8 million investment in East Baltimore, certainly consistent with the surrounding area. And as a permitted use within the zone, the variances we thought we might have needed will go away once the property is consolidated with the adjoining former church lot. We can hear from the architect and Mr. Mesta if you would like. Also, we've met with DBDI staff about this throughout the planning, as well as HEBCAC, which is a neighborhood organization in the neighborhood.
So at this point, is it your position that the property needs any kind of zoning approval?
Well, the setback for the interior side would technically be necessary because the property that will be, the row house property, which has been purchased, but it hasn't been consolidated. It would be consolidated at the time of the building permit application. You might also, frankly, require a parking variance because of there's no long-term lease, frankly, between the parking operator and the credit union. Mr. Mesta can explain what their arrangements have been for their over 60 employees historically.
Okay, currently, we are located about a block and a half from that site. We're on Monument Street, and we park in the Washington Street garage, which we could just stay in that same garage, and it's only a block walk. Hopkins officials have indicated that they would move us across the street to above the Walgreens, so people could come right out of. So, but the credit union's always provided parking for its employees, and would continue that. I don't see that ever changing.
Do you have any sort of formal arrangement with your current parking space?
Well, we pay for it up front for the year, but there's no agreement that says we'll have it 5 years from now.
So in that sense, one could say that a variance might be required for parking just because there's no long-term lease, as the board knows from the current zoning code, much less the old zoning code. We have also renderings of the building to date.
Also site plan. It is supposedly a full lot development. It's a 7-foot by 7-foot lot, about 5,000 square feet. So we'd be using every inch of that to make sure that we get an appropriate home for Johns Hopkins Federal Credit Union.
Step over to the microphone.
Sorry about that.
That's okay.
So it would be a full site development. As Mr. Berry said, this property has been purchased by the Federal Credit Union, and we are trying to alleviate that setback between their two existing properties now, so that we can continue with our development of this project, which is going to take some time. As far as the rendering, we developed this conceptually.
Same drawing everyone's seen.
It should have been included in your zoning packet. The image that Al provided really does show the context of this neighborhood and how it's developed over the years with some buildings that are much larger scale than this one. We're trying to give them what they need to house their employees, but not more than that, and trying to do something that's going to be a very quality design. With regard to the parking, we are planning to tackle some of that. We need to do some geotechnical surveys and see what's below ground, see how deep we'll be going, if we can get any cars downstairs. And also, as Mr. Mesta pointed out, they do have arrangements with local garages. So I don't think we're asking for anything in that realm at this hearing. If we need to come back in the future for that.
Also, most of our members who are coming to visit us work on the campus, and most of the traffic will be foot traffic coming in there.
How many parking spaces do you currently use?
Used for our employees?
Yes.
60. So we'll be adding about 15 more.
And Mr. Berry, you said that there was some miscommunication regarding the number of floors. Looking at the drawings, I see up to floor 5.
Well, there may have been a floor, there was a complete, I can give the board today a complete set. I thought you had a complete set, but apparently when talking with your staff, it may have been a floor or two inadvertently left out. The building hasn't changed for many months, frankly.
Okay.
At one point, we were, this was one of the items that we were hoping to have approved before Transform was put into effect, but because of the decision to wait until after Transform. So there was some lag time, frankly.
Mr. Bonaventure was just showing that on the application, actually, it's written in as 5.
I apologize for that. If that was our staff's fault, then I'll take that responsibility.
And I guess that drawing is a little bit different as the roof that we're showing is, I think, slightly different than the.
Yes, I think there's a.
I think there's a kitchen and a break room.
That's right.
Along with the roof deck. And we're showing that on floor 5, but
Again, the height is well within the 150-foot required, or not required, maximum under that new zoning code.
Do we have something that shows that? See elevations, but not a scale.
Yes, there's the thing I just gave you has a dimension on the elevation. 85 feet, I believe.
Yeah, okay. Okay, we'll have that in the record.
Okay.
Is there anything further?
Unless there are any other questions?
All right, thank you.
Thank you very much.
All right, 2017-279, 5319 Ready Avenue, Bell Cox.
Good afternoon.
Afternoon, ma'am. You're Ms. Cox?
Yes.
Okay, and we have this as an application to install a 6-foot-high perimeter fence around a single-family attached end-of-group dwelling. Is that correct?
Yes.
All right. Ma'am, if you would raise your right hand and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, do we have staff reports?
Planning Department has no comment on this application. Thank you.
Thank you. All right, and Ms. Cox, why don't you tell us about what you're proposing here?
First, I would like to thank you guys for letting me come forward to present the reason for our request for a fence. The main reason we erected the fence was for protection of my family. Over the past 10 years since living in the neighborhood has increasingly become more and more dangerous. Just a few weeks ago, someone was killed steps away from our home. We adopted our pit bull puppy as a way to deter criminals from trying to enter our home, as well as protect the items outside of our home. As you may or may not know, we live on a corner house, and it's an alley, and individuals walk up and down the alley. They throw trash and things into our yard. We also have while I was living on the alley, a lot of people come in and back in and try to do U-turns or whatever on the street, and they hit our fence because the fence is kind of low, about 4 feet. I figured if we have a higher fence, it would be more visible and less likely for people to crash into our fence.
Okay. This is going to be like a wood stockade fence?
No, it's actually a wire fence. You can totally see through it, and it doesn't obstruct our view out or people to see in. You can totally see everything in our yard or in the front of our house.
Chain link? Not chain link.
No, just a wire fence. Just
wire.
Just.
You said wire. I thought you said white.
Oh no, wire.
Wire.
Like a.
I think you mean chain link.
Yeah. Okay.
Yeah.
Okay.
I think. I'm not trying to put words in your
right,
mouth.
Yeah.
But
I
think that's what you mean.
Yes. Yes.
That'd be great. Okay. All right. Any questions? Thank you, ma'am.
Thank you.
(2017-280) 3402 Toon Street, AB Associates. Afternoon, Mr. Pro.
Good afternoon.
We have this an application to construct a 2-story side infill addition, new 3rd and 4th floors with 2nd and 3rd floor rear decks. Is that correct?
That's correct.
I can't remember. Were you sworn earlier?
I don't believe I was.
Okay. Oh, that's right. Your case was continued. If you raise your right hand and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. We have staff reports.
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Prettle, why don't you tell us about what's being proposed?
Sure. It's a rather straightforward renovation and additions to what is a large property in the southeast corner of Canton, almost to Boston Street. This is a project by Charm City Builders. I'm sure you guys are familiar with their work. Mr. Lockman typically will be in front of this board. We're asking for several variances here, primarily for lot coverage, which is a very small variance, 3%. 63% versus the maximum 60%, as well as, I'm sure the reason that you would like to hear more about is the fourth floor. The proposal includes the demolition of an existing first floor addition that you can see on your site plan to allow an additional parking space in the existing rear lot. This is a 100-foot lot, and we believe we can fit 2 automobiles into the existing concrete pad if we take down what is part of the existing first floor addition. In doing that, the property owner would like to gain back some of this square footage by putting on this fourth floor. The fourth floor, due to the length of the lot, is able to be set back nearly 20 feet from the front lot line, and it'll be approximately 45 to 50 feet from the rear lot line, probably not visible by anyone. I mentioned that Toon Street is also at the lowest point. As Canton and Highlandtown move towards the north, it goes uphill, so we don't believe this will be blocking anyone's views. The board did grant a variance for a fourth floor on 1214 South Highland, which is maybe 100 feet away around the corner. So providing this additional parking space is really the need for the variance. The lot being 1,600 square feet is unique in a sense that it's larger than the majority of lots in Canton. And I also mentioned that we are getting rid of a non-compliance in that now we're meeting the rear yard setback requirements. There'll be a 37-foot rear yard setback where there was just under 25 feet before, which when the property was built, or as of before June 5th, that was the requirement.
Okay, and we're showing that Toon Street is 70 feet wide and Highland is 60?
Yes, that's correct.
Okay, I just note that because then it makes it a conditional.
Yes, that's correct.
Anything further?
That's it.
All right, thank you very much.
So thank you. I believe I have the next one.
It's okay, don't go anywhere. Calling 2017-281, 3300 Clipper Mill Road, Cameron Tucker, or NAPRO. All right, and Mr. Prattle, you've obviously been sworn, sir. If you can be sworn, please.
Do you swear or affirm the testimony that you're about to give this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, do we have any staff reports regarding this property?
Yeah, we received a letter of support on August 14, 2017 from the Hamden Community Council, and they believe that it will be a positive impact to the community.
Planning Department has reviewed this application, noted that this is an historic property which has undergone restoration, and recommends approval of the application. Thank you.
Okay, and Mr. Prattle, why don't you tell us about this rather unique appeal?
Yes, and I think in this case, I'd actually like to have Mr. Cameron Tucker, who's going to be the operator of the Cat Cafe, explain a little bit about it rather than getting into the zoning. As I'm sure you're aware, the zoning code doesn't list a Cat Cafe as a permitted or conditional or non-permitted use. So I can be happy to talk a little bit about that after Mr. Tucker explains what his proposal is.
Sure. So Charm Kitty Cafe would be Baltimore's first cat cafe. It's a relatively new concept to the United States, but essentially a cat cafe is a place where you can get a cup of coffee in the company of cats. The cats are all adoptable. We're partnering with the Baltimore Humane Society, and it's a place where people can come into this space, lounge, hang out with the cats, and if they find a cat that they like, they take that cat home with them. So that's basically the concept, and like I said, it's been done in Annapolis and DC.
And I'll add that the proposed location is in what's known as the Whitehall Cotton Mill, which is a mixed-use development of a former industrial building along the Jones Falls. It has multifamily apartments, commercial space, office, and there's several other uses that are proposed. The planning department and the zoning administrator, I think we're struggling about how to view this, and I think some of your data sheet may have a kennel. It's not a kennel in the traditional sense. It's really a cafe, which is permitted use. So this is one of the situations where the zoning code, even the new code, which is supposed to sort of encompass more of these uses, doesn't quite fit into this. But I would just add that he's met with the Hamden Community Council on several occasions. They're in full support, and I would ask that you approve our application.
So how do you handle the, cats use litter boxes, but they normally have to be sort of trained to know where the litter box is, to use it, all that kind of stuff. If these cats are sort of just cycling through, how's that going to work? Because the cat's not really going to know, oh yeah, go find the litter box.
So we've partnered with the Baltimore Humane Society, and essentially the setup is there are going to be litter boxes in the back area. The cats will already be socialized with each other and coming directly from the shelter from the Baltimore Humane Society. So the expectation is the cats that are coming into the space will already have that experience.
I'd add that I believe the zoning administrator didn't cite any specific subsection in his referral of this application to the board. I think it was more just of a clarification and an acknowledgement of what the use is. I mean, if you look at it on its face, it's a cafe. It's just there happens to be cats in it, and an extra level of review.
It's like a combination coffee shop and pet store.
Yeah, sure. Except the cats aren't necessarily for purchase. You can adopt them at some point.
Yeah. All of the adoptions are through the Baltimore Humane Society, so we facilitate the process, but we actually don't take in any of the adoption.
So it really just is a coffee shop with cats.
That's exactly what it is.
Okay.
Yeah, I know.
Curb my interest.
One question. The health department approval, I guess, is just in concept at this point, and you would get that formal approval
Yeah, so
this process, I take it?
So we've met with the health department. They have given an approval for our plan to have pre-packaged food and non-perishable food. So they actually have given that approval.
Formal written approval.
Yeah, it's not going to be, they aren't going to license the facility because what we're selling, prepackaged food, isn't licensed through the Baltimore Health Department, and they've given us that written approval.
Okay.
Any other questions? Okay.
Thank you.
Thank you. Thanks.
See, that was what my cat did last night. 5 o'clock in the quarter to 5 in the morning.
Did we do that one? No, I guess we didn't.
85?
Yeah. 2017-285, 3233, 32 through 3241 O'Donnell Street, AB Associates. Mr. Brittle, we have this as an application to use the existing building for 12 dwelling units with a first floor commercial space, although I understand that the first floor commercial space is being eliminated. Is that correct?
Yes, it's just 12 dwelling units.
Okay, all right. Used building for 12 dwelling units. If all those intending to give testimony can raise their right hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
All right. Do we have staff reports?
We did receive a letter from the young man representing the Canton Community Association right here on August 14th in opposition. However, since he is here to testify, I will let him articulate his issues over there.
Planning Department reviewed this application, noted this is an historic building, and that this is a conversion of an existing structure, which, because it is an existing structure, has complete lot coverage and so on. So there are a number of variances required for approval of this use that in fact simply reflect the existing physical use of the property. The department has no objection to the application and notes that it would have been an unnecessary hardship to require the applicant to provide things like off-street parking by taking down part of the building. Thank you.
Thank you. All right. Mr. Prettle, those conditions stated by the planning department are acceptable to you?
Yes.
Okay. All right. And why don't you tell us about what's being proposed?
Sure. I'll very briefly mention that, there's John Cole, who's the owner and developer of the property. You know Mr. Barry, they be associates. This is a property that my client purchased several months ago, but prior to that, he had it under contract, and we actually filed a separate appeal to demolish the historic building and construct a series of townhomes, which would have had off-street parking through a rear alley. They were 4-floor townhomes. I'll mention that Mr. Tracy and I have been, going back and forth and working together, I'd say quite well on this for probably 4 to 5 months. And even though they're here in opposition, I'm, like to say it's been amicable, and I think both sides have tried to come to an agreement on this. But we reached a point with the last plan that due to the height variance required for the 4th floor and some opposition from adjacent neighbors, although Mr. Tracy will probably mention the association didn't formally oppose the 4th floor. They didn't support it either. We felt it'd be worth taking a look at another option. At that same time, our client had purchased the property and begun to explore some of the structural aspects of demolishing it. And we looked at this apartment plan, and I think in doing so began to feel that from a planning perspective, from a code compliance perspective, this was the right way to go for the property. There's a significant historic value to the property. We're going to be seeking both federal and local historic tax credits, and in my review of the code, we're only seeking a variance for density. I'll talk a little bit about that. In this density variance, it's about approximately 34%. However, the site really necessitates being granted that variance. We have a property with a lot that is over 3 times the average size from the immediate area, and I'll use the 300-foot distance for that. Not only that is there the lot much larger than the existing lots, the floor area that is contained in this property is, in this case, almost 7 times the average floor. We have 17,000 square feet of floor area. To be able to fill that up with what the zoning code allows, which would be 8 dwelling units, we require units of almost 2,000 square feet each. That would almost require them being 8 4-bedroom units, and the plan we're providing now is actually less bedrooms than that. In regards to the parking, we believe, and I'd like to have Mr. French confirm this, that we're not required any off-street parking based on the historic exemption for buildings over 50 years old and that take up the entire lot.
Mr. Prettle is referring to a provision in the zoning code that allows the Director of Planning to consider an application for a waiver of the parking requirement, and the applicant would need to file that request and have that reviewed by the Director of Planning. So no, it's not a gimme per se, but it would require additional consideration by the Director of Planning.
Yeah, and I'll mention that we have met with the planning department about this, and I don't believe there is a formal process based on a previous hearing for a church on South Charles Street. They've begun to create that process for requiring it, but per the zoning code, we meet every provision needed for that. So, and whether it's considered a variance, I think planning's letter already, in a way supports that variance. But the need for the density variance is directly tied to the uniqueness of the property and the hardship of filling up the building. And I'll let Mr. Barry add anything if you have to add. If not.
Well, just briefly, Al Barry with John Cole and the development team. This was an unfortunate situation in the sense that Mr. Cole went to the neighborhood in good faith to do something less, but due to the opposition and some concern that frankly the board might not approve a 4-story for these buildings, he began to, again in good faith and working with Mr. Tracy and his group, come up with something which basically fits the existing envelope of the building. Doesn't go above the roof line and does not provide parking, but we think is something that we're not here before the board today. To require to go back to a 8-unit building would necessitate very large units, and which might actually lead to more people in the building, more bedrooms in the building than under this proposal, which are mostly 2-bedroom units and one one-bedroom unit. Mr. Cole, if it, can certainly talk about the building itself. One time there was some thinking that there's actually a series of row houses that would be easy to tear down. It turns out it's an industrial building that's quite substantially built. We're not even using the basement at all, but because of the construction cannot go into the basement for parking, there's just no way to feasibly do that and provide any on-street parking, off-street parking.
Back to the variance standards, in addition to the uniqueness, which is clear in the size of the property, both in floor area and in the size of the lot. Also look to the city's comprehensive master plan, which the live section, goal 1 and goal 2, I can just submit this rather than going through, but essentially it asks it to preserve historic buildings and expand the choice of and options for different types of housing in the city. So we believe it not only meets the uniqueness and hardship aspect, but it meets all of the other required findings as well.
Okay. Questions?
I'd like to just say one thing to sort of reiterate what Nate said, is that even though there's perhaps been some disagreement, I appreciate the community association's open discourse, and it hasn't been contentious, and I do thank you for that.
Sir?
Good afternoon, Chairman and the members of the board. I'm Dan Tracy. I serve as chair of the Economic Development Committee for the Canton Community Association. We oversee planning, zoning, and liquor board issues for the community. I submitted a letter, and I'd like to just briefly summarize what we said on that. Before I do, I just want to say that AB Associates, Mr. Barry, Mr. Prettle, have been terrific about coming to us with all their projects. They come in advance. They get our input, they respond to our concerns, and this is probably one of a very rare moment when I'm standing up here in opposition. This building, as they said, is an old building, a 3-story big building, 17,000 plus square feet, and it's been used as offices over the last several years. It occupies, as has been said, the whole lot. There's no off-street parking at all. But given its use as offices, the impact on parking in the immediate neighborhood hasn't been particularly significant, particularly after normal business hours. Now we're getting a plan here that's going to have 12 new residential apartment units. I think there are 11 2-story or 2-room and 1 bedroom that are going to be in there, and we're going to see 12, 18, maybe as many as 23 cars now going to be generated out of that building onto the adjacent streets, particularly after normal business hours when demand for parking in the community is greatest. A couple of years ago, with the help of Councilman Kraft and the Department of Transportation, we put in angled parking in a lot of places in the Canton community, particularly on Elliott Street and Clinton Street, which bounds this particular property. And that was done to address the real parking deficit that we have in that neighborhood. Now, if this were to happen, the additional load that this building will place will just do away with the gain that we got from that angled parking and really exacerbate the parking situation in the neighborhood. We would like to see this building. It's pretty unattractive. We'd like to see it renovated or torn down and replaced. As has been mentioned, there was a previous application by these people to put in 4 townhomes. And frankly, we were getting to the point where we approve it. We did have a couple of neighbors that didn't like the height. It's going to block their view of the harbor. And, but they came late in the game, so that when that happens, when we have a project that we like, but we have some objection in the neighborhood, then we have to go to our board and take a vote. And we just didn't have time to do that. So I wrote a letter saying we like the project, but we can't take a position on the height variance because of this late blooming, concern. That kind of thing I think we would like. But in any event, because of the parking impact, we would be remiss in our duty to our community if we didn't come in here and oppose this. It's going to be significant. And it would be injurious to the use and enjoyment of the adjacent property, and it would threaten values because of the real parking problem that this would pose. But that's all we have. Thank you.
Thank you.
Yeah, I'd just like to go on the record by saying I don't necessarily think that apartments nowadays necessitate parking. I think that perhaps a building of such as this almost encourages people to not have a car, to use the circulator, to use the water taxi, to take an Uber. An Uber every other day or 3 days a week, probably if you're taking it downtown, is probably less than a car payment, insurance, and fuel. So I certainly can relate to the community and their fear for parking implications, but I do believe that it can almost encourage people to sort of get away from being required to have a vehicle.
And I'd just like to add one more thing, is that in our application, I'm not requesting a variance to off-street parking. I'm going to request the exemption under the new zoning. You're operating under a new zoning code, which has a specific provision to address this exact situation. And we intend to seek that, to take that route. And, we've already met with planning in regards to that, and we continue. So we're really here only to ask for this density variance. We're happy to have a condition that notes the director of planning has to sign off on it, but I'm not here to request a parking variance. I'm here to request a density variance on the condition of the section 16 dash, I believe it's 601F. Yeah, 601F. There you go. Thank you.
All right. Thank you.
All right, thank you.
Calling 2017-289, 123 South Chester Street, Brian Pritchard.
Brian's an associate at SMP Architects. It's the firm that I work at as well. Adam Tawney. Andrew Crummy is the property owner.
Okay. All right. Your name again, sir?
Adam Tawney.
All right.
Tawney.
All right. And Mr. Tawney, we have this as an application to rebuild the existing floor, side and rear portion of structure, construct second and third floor side and rear additions, use the first floor as a restaurant, use the basement as non-accessory offices, and continue the, quote, expanded, end quote, 2 dwelling units on the upper floors. Is that correct?
That is correct.
All right. If all those intending to give testimony can raise their right hands and be sworn, please.
I swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
All right. Do we have staff reports?
We received a letter from Butcher Sills Land Use Committee on August 8, 2017 in support of this appeal.
Planning Department has reviewed this application and recommends approval of this application. Thank you.
Thank you. Okay, and Mr. Tawney, why don't you get into what's being proposed here?
Sure. It's an existing structure, brick structure that's got an existing grocery store on the ground floor and 2 apartments above it. It is a little bit over 15 feet wide by 70 feet deep. The entire lot is covered by this 3-story structure, with the caveat that the last 12 feet or so is a single-story addition that was put on a number of years ago. The single-story addition will be torn down and replaced with a full 3-story addition, so the lot coverage will not change, though the actual bulk of the building will be increased. The 2 apartments upstairs will remain, and that's about it. The new zoning code has a special provision for a neighborhood commercial establishment, which we're seeking conditional approval for. That will allow the restaurant on the first floor and the offices on the ground floor to, or excuse me, the offices on the basement floor to exist by right, and also alleviates the parking requirement for those. And I believe the parking for the 2 apartments is grandfathered in as not being provided.
And what kind of restaurant is going in the first floor?
It would be a full-service restaurant from 7 a.m. until 10 p.m. From breakfast, lunch, and dinner, full-service seasonal restaurant.
I didn't catch his name.
It's Andrew Crummey, Crummey.
Questions?
Just put forth a little bit more. Andrew is active in the community. He lives a couple doors down. I live a block and a half from the establishment, full support of it. It's an amenity to the neighborhood. We're all excited about it, so we're looking for it to be approved.
All right. Thank you, gentlemen.
Thank you.
Thank you.
Okay. And we're off.
You all right there, Martin? Sure?
Yeah. Yeah. Yeah, because you can't appear in court, you can't file court filing. You can't sue, that's right.
And that's why I'm not sure the LLC has authority to do that because it's existence.
BMZA.
See there, it would
Liquor
be,
board has a guy that comes every week. Eventually gave him like a shirt, an honorary shirt. I mean, he comes for years.
entity itself
Hilarious.
isn't the one who's doing anything.
Zoning board's not his pocket.
But it is, to me, it is because it's authorized. It's taking action as an entity authorized to file zoning.
There's one healthy.
The appeal is being sought
He has a little girl and he was
because they're the ones who are going to be owning it going forward.
Yeah, but the owner, the appellee only has
the guy.
authority that the owner has.
Thank you.
The owner doesn't have authority to file. You can't authorize a user to file.
I think that
That's over.
I think that the
No
owner,
one ever told me that.
if the owner was looking to authorize, was looking basically to have an agent, that would be correct, but they're not. Because then the power, because the agent has no more power than the principal. But here it's not. They're not legally.
There were other references made that to that particular entity that left off of that brief. So I think there's more to the story than was shown. I printed it off, I just didn't bring it over. Prior to Stevens, there's another entity with the same name that was not in good standing, but was still active. So that particular entity had not been forfeited.
Well, this entity is not in good standing, because I checked while we're here.
Yes.
Yeah, there's another development corp that is in good standing or something, but supposedly the fee owner is not in good standing.
And wasn't at the time of the filing of
Correct.
the application, yeah. Yeah, that was the one issue that resonated with me as I saw being problematic.
Yeah, and that was why, when I looked at the application that was filed, the owner's not the applicant. Prospective owner is the applicant.
There was some testimony by the opposition that there's this provision that requires the authorization of the owner to file an application, right? File an appeal, sorry.
The authorization, yeah.
No, or that they authorize whoever is seeking the appeal.
Authorized by the owner of the property.
That's right.
Right. And the owner of the property is the entity that is not in good standing.
Right. And
The
so,
authority, and that's a good thing. You have the authority to authorize.
Right.
and that's what I was saying, that it would make a difference if you were engaging an agent, but they're not. And the limitation is on transacting business. And so here, where there's nothing that's being given or exchanged, and there's no obligation that's being created by the owner to do anything.
Well, I'm not so sure about that, because if the authorization is, to authorize a third party to get approval to conduct a business in your property, presumably you're going to reap some benefit from that, lease payments.
Mhm. That might affect any obligations between the, I guess, that might affect the binding contract between, I don't know if it's gonna be a new owner or if it's gonna be a landlord, but it might create an issue as far as enforceability from the landlord's perspective. But from our perspective, the question is authorization of someone else to to file something on their own behalf, is that transacting business? And that I do not think so, because there's nothing as a part of that transaction that's exchanged that's of value. The limitation is on transacting business.
Well, I mean, isn't the act of
It's also,
giving-
by the way, it's also cured when you file the form. It's retroactive.
Yeah, all I gotta do is
It
fix it.
cures everything that was done before that.
Well, for
So
corporations, it does. The statute's not clear for LLCs.
That's true.
There's no corollary, there's a provision, express provision in the corporate statute.
Yes.
But in the LLC Act, there is no corollary to that for the LLC statute.
Yes.
So it's a little bit unclear.
But
Yes.
the cure,
He
restores
cures
the
it.
entity.
but the
Yeah.
cure, even if it's.
I know that that's what we do with ours, and we have.
I mean, you
issues
could,
with
you
that.
could file the Form 1, and then they could simply just reauthorize it,
Authorize it.
and that's simple enough
Yes.
to do.
Yes.
Doesn't any agency argument go between the possible principal and agent doesn't affect, like this, for example?
Well, my point is, I don't think, my concern is that the principal didn't have the authority to authorize.
But there's
the
not
agent.
a principal and agent. They're not engaging an agent. They're doing something on their own behalf. Like I said, if it was a principal and agent situation, that would be correct. But it's not a principal and agent. So if there was a real estate broker who was being engaged, and the real estate broker was authorized to go out and solicit and get contracts, well, yeah, in that circumstance, it wouldn't be any contract entered into or any obligation incurred by the agent. It's invalid because it doesn't have any power that its principal doesn't have. So that way it's invalid. But here, there's not an agency that's being created.
But isn't the question really, if an entity is forfeited, is there any authority on behalf of that entity to do anything?
Yes,
Even
because
authorize someone to go file an
Because,
application?
again, the prohibition is on transacting business. And here, because there's nothing that's given or exchanged of value, there's no obligation that's being created on the fee owner to do anything. No, that's not transacting business,
Let me,
because they're not doing anything.
let me make a suggestion. We have a really sharp staff lawyer here. Why don't we defer, get something from our counsel? So this is purely a legal issue.
Yeah.
It's the pinstripes that makes them so sharp.
Yeah.
Yeah, I'd be okay with that suggestion.
Jay, you good with that?
Yeah, good idea. See you, Bryson.
Take care, Bryce. Thank you. Getting any sleep, by the way? The answer to that is probably no.
Yeah.
All right, now what else are we talking about here?
O'Donnell, oh wait, what was the one that had this, the last one, Key Highway? I had a question on that one. Parking lot.
Yes. What they were really seeking was I guess an accessory parking lot. They were looking, it formerly had been accessory to the restaurant. Now they want to make it accessory to the office building. It's across the street.
But I don't think it was ever formally.
Accessory to the way the definition reads for accessory is that it has to be on the same lot, and I think they forfeited that
Yeah.
ability
Severed
once they
it.
subdivided it.
Exactly. Yeah, it can't be accessory.
That's right, yeah.
In general, I think you guys may want to contemplate the degree of what constitutes temporary or just a sunset, because temporary use permits in this code were designed to solely be funneled through the zoning administrator.
That's right.
And so I think really the question as to whether or not he is seeking a temporary use, and if so, then he would have to go through the appropriate administrative channels, or whether or not you guys are granting the use with a sunset clause associated with it.
See, and there, the issue with those waterfront parking lots was that I wanted to see them go away. And I still don't really get why they're I guess once they gave the explanation, that sort of was just like, well, we really want to use it, we really want to use it as accessory to our office building, and so that we can offer that as an additional amenity to our tenant, to say that they've got this parking that's associated now with the building. And I don't think that is what certainly I don't think that's what the urban renewal contemplated.
Definitely not. The other thing was, he said, I made a note that until we build the structured parking,
Yes.
this would be the parking. That, in and of itself, is a bit of concern, because it means there's no commitment to build the structured parking yet.
Mm-hmm.
And this is the safety valve that allows that developer not to have to build the structured parking right.
Yes.
Which is not something that's under the control of this urban renewal plan, because it's across the street, but the department certainly doesn't see any reason to use an off-site, out of the urban renewal area property as a reason to create a surface parking lot. And as I mentioned, the fact that it's operated as a surface parking lot without proper permitting or any type of review does not in any way give them a license to continue to use it as an off-street parking space.
No, and I don't think that's the position they're taking. They're here asking our permission to do it.
I mean, we would want to talk to these guys further. I mean, the whole thing about the asking for some type of review by the planning department, that's only just happened when we indicated we were opposed to the parking lot use. And we have yet to have that meeting. I don't know how that's gonna go, obviously, because that's down the road.
Is it then premature for us, or should they go through the process with you guys?
We feel, that they should be asking for a temporary parking permit, from the zoning administrator, and then, bring the development proposal in and get moving on it. If they need a second temporary permit for another 6 months or whatever, fine. Get moving on developing that property. They went to all the trouble to subdivide it.
I don't think there's any
Now use
cap
it.
for the zoning administrator where, I mean, there's a cutoff where he can't issue another temporary permit. I think that he
There
has
is not.
like fairly maximum autonomy on that.
There is not. We just didn't see a justification for this. To us, 5 years is not a temporary parking space, temporary parking lot.
Hypothetically, if the board were to, condition approval on a shorter period, what happens at the end of that period? It becomes an enforcement issue then at that point, to force them to cease using it
Yes.
as a parking lot?
There's already an enforcement issue.
Right, well, that's true.
So to get it back to the zoning administrator, do we remand it back? Or do we
No,
deny
there's
it?
nothing, if they were denied, there's nothing to keep them from either seeking a waiver from the Department of Planning from the Urban Renewal Ordinance, or from seeking a temporary parking permit from the zoning administrator. They want to get our approval because I guess they feel they're not sure that they would get it from the Department of Planning. And and I guess their lender wants something a little bit more definite than just, okay, we're gonna get a 6-month.
It'd be permanent temporary approval.
Yes.
But I guess they could run the numbers for parking in terms of revenue. And for a lender to have a piece of paper that says this many cars, this much revenue equals this many dollars.
Yeah.
Full circle. Tell them they have to exhaust their administrative remedies first.
It takes a long time to get a building out of the ground.
No, it does.
I mean, I would give them a year. That would be my suggestion.
If you get that from Jeff.
They're here. They're here.
Because here's the thing, it's the question is, it's the precedent of, what are, because there's a lot of development that's going on down there. And so it's gonna become a question of sort of, what are we gonna say? Are we gonna hold people's feet to the fire on, which I think was the intention of both the code and the urban renewal ordinance, in terms of getting these things built, or you're gonna let people be like, okay, well, we'll sort of look at everything on a case-by-case basis, and maybe, depending on your circumstance and what you say, then maybe we'll give you this period of time or that period of time. But in either event, aren't we saying something if there's already a process for issuance of temporary permits, and we're issuing permits in excess of that? Aren't we, well, if he's the guy you see for temporary ones, then you see us for, what is it if it's not temporary?
Right.
So. All right,
Anybody have questions about 176?
yeah, for some reason, I don't have anything written there, and I don't really know why.
Which one?
The first one.
The grocery store with a kitchen.
I just said, you know, I wrote a note to say with condition with no cooked food. That, you know, that was, he said he's gonna use the kitchen to prepare salads.
And that may be from a previous appeal that never got finalized on that property where they applied for 2 DUs. They
Yeah.
got authorization, but they never finalized the UNO.
Right.
So they may have the interior fitting for those 2 DUs without the appropriate permit.
But yeah, he said, only cold food, salad, sandwiches.
Mine or yours?
Good question. I think those might be.
I think they're yours.
And a delicatessen is part of that whole retail goods establishment with that categorical umbrella of retail goods as a grocery store in addition to with the delicatessen. So it does meet, like adding that deli is not really adding any increase.
Doesn't really change it.
Mhm.
I guess it's, as I'm going back through it now, I guess that's where I wound up, was that if we restrict it like that, it's basically what we said. No hot food, only cold foods.
Yeah.
And then what about the 6-foot fence? For killer.
For the puppy?
Oh,
I didn't
that's
have a problem with it.
great.
I think that it is, you know, and she was talking about people walking, because it is on an alley. People do, you know, walk up and down those, and you know, we've heard it in more than a couple of cases where people just drop garbage in people's streets, I mean, in people's yards. It's a chain link fence, so it's not going to obstruct the view, which I guess is the biggest thing there, since it is a wide alley, so people might use it for cars, so you're still able to see through it as you're pulling out, so I didn't have a problem with it.
Yeah, I didn't either. I mean, usually I'm opposed to the 6-foot fences in the
Yeah.
front, but for this one, I was okay with it.
Yeah.
I circled O'Donnell Street, but I'm not quite sure why. I think it was because the parking, but I think they answered the parking at the end.
Yeah,
Parking.
that's right.
And actually, he said 2 weeks ago, whenever his last hearing was, there was no process for requesting the
Right.
planning director's review. Now there is.
Right.
In those 2 weeks, we've created the form, and it's now available for people to use, so we can go ahead and move that.
So we don't have to address it at all, parking that is.
Yeah.
And hopefully we'll have people have that application at least into them now. I spoke with Laurie last week and they were still finalizing it. I'm meeting with her tomorrow, so hopefully I have a final product that we can just sit at the front desk for people in those circumstances.
Oh, Ashland Avenue, I had a question on that one, as far as parking for that. That was the credit union.
Yeah.
5, 6, 7. Yes.
Cases, numbers.
No. 78. Here it is.
No, it takes me an entire day to do it.
They weren't showing any parking. This is the gross floor area totals 24.5. Then the appellant must provide 31 off-street parking spaces. They weren't providing any
bicycle spaces too.
Mm-hmm. I think it was 3.
I believe it's, so it's one for every 10,000.
Oh, maybe 1.
So, yeah, that's
Two.
3.
That's 2, I think.
Yeah, 2. This is 24.5. But they were getting spaces from,
Garage.
yeah,
Yeah, I think they have the spaces. I mean, I think the issue for us is, I mean, we've required people in the past to document that.
Right.
yeah.
It's actually codified in this one now too, as far as off-site facilities, that they have to provide like a 20-year long-term deed, or provide records that, like, the owner of that structure is the owner of the other building. It's, I think it's like
Okay.
16.4, but they codified it as far as the requirements for off-site.
Your code is easier in that respect.
Yeah.
So, 16401C, it's 330, page 332. Oh, you're fine. Bless you.
Thank you. Yeah, and that they were getting them, like, basically they were paying for them annually, but they didn't have, yeah.
Recorded deed restriction.
What the hell's a deed restriction? It used to be leased, didn't it?
Yeah,
Yeah, it used to be a lease.
east.
Those damn planners.
Well, that's pretty restrictive.
I guess what that means is, I guess the owner of a property restricts himself or herself?
So what?
I don't know.
Finding the owner of the lot and the owner's heirs and assigns to maintain the required number of parking spaces for the duration of use. Paragraph 3.
Mhm. Finding, lot, Okay, so it's basically that condition that we normally put in
Or the consultant.
to make it part of
Friendly
their deed.
Midwestern.
So,
That's the thing I like about this book. It's the one thing the council did right for me.
Okay.
Is they gave you this one.
we have the ability to waive the park.
Very happy. I'm like, I'm not letting this go down.
100% parking variance?
I didn't have the same council's question.
Yeah. Mm-hmm.
I guess what I'm, well, okay, so. Yeah, I mean,
Where's
can we provide a variance and then,
Where's the variance for hardship? Parking bar variance for hardship.
Got him back at the end of last week. Well, it's gonna be a similar length.
Yeah.
Cut it, because fixed amount for salt. And so the purchase order is in. Just
in the world do you all have this stuff committed to memory?
I already have like everything, like the files that you've been maintaining are all congruent to what the paper. It's just a matter of actually getting Microsoft Word. And it's driving me crazy. Oh my God. I'm like, come on. But I'm hoping.
Yeah.
Next time.
Yeah.
I was praying it was
So,
today, but
it's possible to
you know,
have
they got
100% variance
increasingly
and
likely
not place the
unlikely
condition.
as the way. I'm like,
Yeah.
Okay, that seems very
Mhm.
burdensome and
Mhm.
not likely to be a friend, to be quite honestly.
That's the kind of luck I'm running into right
it sounded like. So I think that sounds like the way to go.
Yeah. That would agree.
And then on Huntington, I think that's one where we can have some restrictions on, basically just limiting them to what they were offering.
Huntington.
It's the Oyster Bar, Remington.
I thought that was one we said we were gonna
Yeah.
get Derek to do some
Oh,
research.
that's right.
For that
The issue of the authority of
That's right,
the
yeah, yeah, yeah.
corporation, or the LLC.
Mm-hmm. All right, any others?
Good on everything.
No pressure there.
Okay. All right, 2017-176, 1101 North Carrollton Avenue. I'm a yes, conditioned on that there be no hot foods served, only cold foods.
Yes.
Yes, with that restriction.
2017-229, 5139 Weathersville Road was by consent, and they've got to send you in the CHAP authority, the authorization to proceed. 2017-259, 612 South Bolden Street was by consent. 2017-268, 1300 through 08, and 1310 through 20 Russell Streets was postponed. 2017-269, 522 South Bethel Street was by consent. I think he also was going to be sending in the CHAP authorization to supplement the record. 2017-271, 2745 Huntington Avenue, we're holding. 2017-272, 337 South Chester Street is postponed. 2017-274, 901 through 925 North Milton Avenue was by consent. The planning department conditions. 2017-278, 1923 Ashland Avenue. I am a yes with a parking variance, but with a condition that they maintain, what was the number of spaces they said they were going to get?
60.
Okay.
Currently has 60.
I think he said he was
He
going to
said he
get
would
like
add
50
15 more?
Yeah.
Yeah, I thought he said something about, all
Yeah,
right.
he said we're going to be adding 15, so that's condition on maintenance of 75 spaces.
Yes.
Yes, with
Agreed.
that condition.
2017-279, 5319 Ready Avenue, I'm a yes.
Yes.
Agreed.
Yes.
2017-280, 3402 Toon Street, I am a yes.
Yes.
Agreed.
Yes.
2017-281, 3300 Clipper Mill Road, I'm a yes.
Yes.
Agreed.
2017-283, 504 South Decker Avenue was by consent. 2017-284, 1156 Hull Street was by consent. 2017-285, 3233 through 3241 O'Donnell Street. I'm a yes, and we should specify that that's with no parking variance that's being sought.
Well, that one's subject to Director of Planning.
Well, yeah. Yeah, that's what I'm saying, that there is no parking variance that's
Right,
being
right,
sought.
yes, right,
or
okay,
granted.
right.
Yeah.
Right.
Yeah.
Yes.
Yes.
Agreed.
2017-288, 1209 North Rose Street was by consent. 2017-289, 123 South Chester, I'm a yes.
Yes.
Agreed.
2017-291, 1321 Key Highway, I'm a no.
No.
I am a, no, I didn't go to the zoning administrator.
Yeah. Took a while.
I had to think about it.
Make it dramatic for the last.
Yeah, okay.
Yes.
Okay.
Doesn't matter at that point anyway.
No, no.